Good afternoon, everyone. We're going to get started in about 3 minutes or 4 minutes. And I want to let everyone know that the probate bill is going to go first, indemnification agreements second. And I know the room is very crowded right now. If you are here for the indemnification agreements bill and you wish to wait in VLA to free up some room for the folks who are here for the probate court bill, that would be appreciated. We'll do 2 rounds of introductions, so you won't miss anything. Thank you. Good afternoon, everyone. Thank you very much for all your patience. Welcome to the Joint Standing Committee on the Judiciary. We have 2 bills that we're going to take up this afternoon for public hearing. The first will be LD 1766, which involves the probate judges. And then the second is LD 1761 involving indemnification agreements. We'll start with committee member introductions. And I know that kindly some of the folks who are here for indemnification have gone to an overflow room. So we'll do 2 rounds of introductions just so that everyone gets to introduce themselves to the public. And with that, we'll start our introductions. Representative Caruso, would you like to begin?
Thank you, Madam Chair. Good afternoon, everyone, and welcome. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Good afternoon. I'm Mark Babin. I represent House District 3, Northeast Aroostook County. Good afternoon. My name is Ellie Sato. I represent House District 109, which includes part of Gorham.
Hello, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Hello and Happy New Year. My name is David Sinclair, here for the people of House District 50, the city of Bath.
Good afternoon, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good afternoon, all. I am Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good afternoon. My name is Danny O'Halloran, and I'm from District 20, representing the industrious city of Brewer.
Hi there, Dave Hagan. I have Senate District 10, 12 towns surrounding Bangor, not Bangor.
Good afternoon. I'm Amy Kuhn. I represent House District 111, which is most of Falmouth, and I serve as the House Chair of the committee. Welcome.
And my name is Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and a little bit of Scarborough, and I serve as the Senate Chair. You'll notice committee members going in and out today because even though it's the first official day of session, we are all very busy. And at this point, I'm going to turn the gavel over to Co-Chair Amy Kuhn.
All right, we're going to begin with a public hearing on LD 1766, an act to incorporate probate judges into the main judicial branch. So first we'll call up the bill's sponsor to get us started.
Good afternoon, everyone, esteemed members of the Judiciary Committee and Co-Chair Kuhn. I am Ann Carney. As you know, I proudly represent Senate District 29, South Portland, Cape Elizabeth, and some of Scarborough. It's really a true pleasure for me today and an honor actually to introduce LD 1766. This is a bill entitled An Act to Incorporate Probate Judges into the Main Judicial Branch. I just want to note as I get started that the commission that was formed in 2021 and worked very hard and diligently to formulate a plan, and many others, stakeholders, worked very hard on developing the plan that you now see before you in the form of this legislation and the amendment that I'm proposing today. It's truly a group effort, and I want to give thanks to all of the stakeholders who worked so hard on the legislation and who are here today. This legislation gives us an opportunity to implement a constitutional amendment that was approved by the Maine voters in 1967. So in 1967, Maine's voters approved a repeal of the provision of Article 4 of the Maine Constitution that had required the probate courts to remain outside of the state judicial system. The language of this constitutional amendment provided that the amendment to incorporate the judges, the probate judges, into the judicial branch would become effective, quote, at such time as the legislature may by proper enactment shall establish a different probate court system with full-time judges. And that is what this legislation gives us the opportunity to do. So why did this reform matter to voters in 1967, and why does it matter to voters today? Well, the answer is the same. Individual county-based part-time judges do not have the resources necessary to meet the needs of Maine people in court matters that involve personal liberty, such as guardianship matters, complex financial issues related to managing an individual's or family's life savings, such as trust and estate actions do, and preventing the exploitation of children, Mainers with disabilities, and older Mainers. Necessary resources that this legislation would allow probate judges to have include some very important things. One is the professional development and training that's provided to judges and justices within the judicial branch. We've actually had legislation that asks to allow the probate judges to participate in judicial branch training, and because of the potential conflict of interest, that could not happen. That would no longer be a problem with the probate judges being part of the judicial branch. It would create a unified system that ensures Mainers in Fort Kent, Elliott, and everywhere in between receive consistent and fair outcomes under Maine's probate laws. It would allow for efficient and cost-effective training and administration of Maine's probate courts. It would allow increased access to guardians ad litems and attorneys for individuals in a disputed petition for appointment of a guardian or conservator. And for those who will be appointed to serve as full-time probate judges, serving within the judicial branch, this legislation would allow freedom from apparent and sometimes actual conflicts of interest that arise from having judicial authority over an attorney in a probate case who is that judge's opposing counsel in a private practice case. Is this the right time to incorporate the probate courts into the judicial branch? Through our work as a committee, and I'm talking about us as the Judiciary Committee, we have acquired so much significant and detailed knowledge about the modernization of the judicial branch that is occurring right now, from implementing the Maine e-courts, the judicial branch's new e-filing, online payment, and electronic court records and case management system, to replacing and renovating courthouses so that they provide safe, accessible place for Mainers who seek justice. Some projects, like the Capitol and York Justice Centers, have been completed, and many committee members have visited those complexes. Others, like the e-court system, are nearing completion. We have also strengthened our state's ability to provide for the Sixth Amendment rights of criminal defendants, of parents in child protective cases, and to appoint guardians ad litem. And that's through our work on the public defense services. Perhaps most importantly, and why now is the right time, we have a plan and we have broad support from the judicial branch and from stakeholders for incorporating the probate courts into the judicial branch. During the 130th legislature, a resolve established the commission to create a plan to incorporate the probate courts into the judicial branch. Testimony in support of the plan in 2022, when it was presented to this committee, is as follows, and I selected this quote because I thought it nicely encapsulated the work of the commission. The 15 members who comprised the commission, ably supported by 2 experienced members of the Office of Policy and Legal Analysis, had precisely the right knowledge, experience, and perspectives to design a different probate court system. The commission's detailed and comprehensive report reflects its careful, thoughtful, and hard work. The report's proposed plan would finally implement the will of Maine voters in 1967 in a way that reflects Maine's current needs. And to give due credit to that wonderful quote, it's from Deirdre Smith, Esquire, who appeared before the committee in 2022. The amendment that I'm presenting today, which you'll see a summary of it is attached to the testimony, makes some changes in the legislation that was introduced and made its way through the legislature as far as the appropriations table in 2022. First of all, it updates the implementation timeline and the plan to be consistent with the election cycles and terms of current probate judges who serve 4-year terms of office. So you're taking 16, some part-time, some full-time probate judges who are all on one of 2 different election cycles, and you're incorporating them into the judicial branch without interrupting with any term for which they have been elected. And that just takes a lot of hard work and detailed scheduling. Second, Although not reflected in the text of this bill, the amended version of the bill authorizes the judicial branch to hire a project manager as soon as possible, and general fund appropriations will be added to the bill for that purpose to help the judicial branch prepare for the establishment of the state probate court on January 1, 2029, which would be when the implementation is complete. The state court administrator suggested this position as a way of ensuring the efficient and effective implementation of the plan. Incorporating the probate courts into the judicial branch involves considerations of facilities, technology, and other administrative matters. Someone mentioned to me that it includes the slope of desks that some clerks rely on currently in some of our courthouses. And those are things that weren't within the scope of the commission in the drafting of the plan, but they are things that need to be addressed before the plan can be fully implemented. Bringing on a project manager early in the implementation will make the transition smooth and will ensure that the incorporation is methodical and cost-effective. I'm happy to answer any questions you have either now or during the work session, and I want to thank you very much for your consideration today.
Thank you. Committee members, are there any questions for Senator Carney? Representative Henderson.
Thank you, Madam Chair. Thank you, Senator, for presenting this. I know you've been part of this work right from the get-go. Would you be willing to walk us through what some of the amendments that you provided are? I think that would be helpful.
Yes.
Thank you.
So if you look at the summary of the amendments that are attached to my testimony, you can see that the original timeline in the text of the bill when it was introduced in 2022, they assumed a much earlier implementation timeframe, and they also assumed a timeframe that was offset by 2 years from what this timeframe will be. And so what we needed to do was to adjust both the different judges who would be how the specific judges would be addressed in a way where they would be elected but serve 2-year terms, and then the judges who would be who would serve out their term, and then their district would become subsumed within the judicial branch at the end of their 4-year term. So in other words, the bill has to create some 2-year terms and some 4-year terms in order to not interfere with anybody's elected term of office. The other really significant change, as I mentioned, is the inclusion of, well, let me step back a second. The other change had to be with a shift in the counties that were impacted, or the order in which different counties were impacted, because again, we're dealing with a totally opposite cycle of judges and their election cycles. And so in this case, we chose as the first group of counties to be incorporated into the probate court system. We chose, I have to make sure that I get this right. I'm going to take that one under advisement because this was like doing a crossword puzzle without any clues. And so I need to have a little bit more time to tell you exactly what the new schedule is, but I appreciate your interest in digging into that. And then the big change would be the hiring of a project manager. I think what we learned through implementation of the e-court system and through other major changes that we've been part of as a committee, that having one person in charge of the plan to keep a timeline and to keep track of all the details and make sure that the plan is rolled out in the most effective and efficient way possible is really the key to success. Yeah, I hope that answers your question. I'll give you the nitty-gritty when I have a moment to sit down and sketch it out.
Are there any other questions, committee members? I'm not seeing any. Thank you.
Thank you.
Representative Poirier, I see that you've joined us on Zoom. Would you like to take a moment and introduce yourself?
Thank you very much. I'm Jennifer Poirier. I represent District 70 in the House, which is Skowhegan.
Welcome. All right, let's begin with folks in the room or who are here to testify in support of this legislation. Please step right up to the podium. Just 1 second. Mr. Brodigan.
Thank you for letting me interrupt you, Mr. Brodigan. I just wanted to point out to my colleagues, and in particular to Representative Henderson, that if you look at the very last page of the summary, there actually is a timeline and schedule, which will show you the order in which the plan will be rolled out. And that chart, as you might imagine, was drafted by Janet Stocco, our amazing legislative analyst, and she can probably explain it to you even better than I could. Thank you.
All right, thank you. Please go right ahead.
Good afternoon, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is John Brodigan, and I'm here today on behalf of Legal Services for Maine Elders, and very happy to testify in strong support of LD 1766. LSC supports LD 1766 because it addresses a long-standing structural problem in Maine's probate court system that affects fairness, consistency, and public confidence. In 1967, Maine voters approved a constitutional amendment repealing the county probate judge system provision, but they made that repeal effective when the legislature created a different probate court system. The legislature never completed that work, so the repeal has remained pending for decades. LD 1766 finally activates that amendment by modernizing the probate judiciary while preserving the functions that are working well, particularly the clerk system. The core problems have been smoldering for decades. Maine has 16 county probate courts that operate as independent bodies. They are funded through county budgets, which ultimately come from local property taxes. Probate judges are elected, not appointed through the same screening, confirmation, and evaluation systems that apply to judicial branch judges. There is no chief judge with supervisory authority over the probate courts. Schedules, practices, and training vary widely by county. The result is that Maine people can face very different experiences of justice depending on where they live. Then there is the very serious ethical problem that others are addressing in detail and is addressed in other written testimony that has been in the record for the commission that has been referred to in other hearings over the past many years. LD 1766 addresses these by transitioning the judges into the judicial branch. Current elected judges would finish their terms. They would be replaced by 9 appointed full-time judicial branch probate judges, and including a chief probate judge, as you've heard. We believe that this will advance equal justice, improve consistency, and strengthen impartiality across the state. At the same time, the bill preserves the registers of probate, who play a critical role in informal probate and public-facing assistance, and they help people navigate forms and processes, and many families can actually complete their business before the probate courts without hiring a lawyer. LD 1766 keeps the register's functions intact. And we do support the amendment. The judicial branch has requested a project manager. We believe this will be an important step to planning the implementation of this, and the adjustment of the timelines is, of course, appropriate. Let me just close by saying the Joint Standing Committee on the Judiciary is in a unique position. You are not only responsible for many policy and substantive law decisions affecting housing, civil rights, legal process, but also for legislative oversight of the judicial branch itself. You'll note that in the description of the jurisdiction of the committee, the very first phrase, the very first topic of jurisdiction is judicial branch organization. So this is key, and this is a high calling for this committee, and perhaps one of the most important far-reaching bills that you'll be considering this session. So this has been studied for decades. What's been missing is action, and we think this is the year to finally get this across the finish line. So happy to take any questions, and thank you for your time.
Are there any questions, committee members? Not seeing any. Thank you.
Thank you.
Others here in the room who are here to testify in support, please just come right up.
Good afternoon, Senator Carney, Representative Kuhn, members of the committee. My name is James Haddo. I live in Buxton, and I am a lawyer. I've been a member of the bar for 40 years here in Maine. I have practiced in most counties in both state and federal courts, and also in the probate courts of the state of Maine. And I'm not here in my capacity representing any entity. I'm here only because I think as an attorney with responsibilities to my clients and as an officer of the courts, that LD 1766 is probably the single greatest step that the government of the state of Maine could take to support confidence in the judiciary, confidence in the judicial process, and to promote fairness and consistency in judicial outcomes across the state. It's crucial to understand in considering this bill that probate courts in the state of Maine handle matters that are every single bit as important, every single bit as momentous as any other court in the state, any court at all, including the federal courts in the state of Maine. I personally have been involved in estate matters where the amounts in controversy were in the millions of dollars. I've been involved in proceedings where the personal liberty of individuals was at stake. And to have those decisions made by elected part-time judges does not provide the kind of confidence, doesn't generate the kind of confidence in the process that comes from having full-time, dedicated judges who are properly resourced, properly trained, and have the kind of experience that's necessary to be able to handle those kinds of matters. At the bottom line simply is that the judicial system in the state of Maine desperately needs LD 1766 for a variety of reasons, and now is definitely the time to integrate the probate courts into the judicial system and to provide full-time qualified judges to sit on the benches in those courts. Thank you very much. I'd be happy to take any questions if there are any.
Thank you. Are there any questions? Not
Thank you
seeing
very
any.
much.
Thank you.
Good afternoon, Senator Carney, Representative Kuhn, and other members of the Joint Standing Committee on Judiciary. My name is Deirdre Smith. I'm the Director of Litigation for Pine Tree Legal Assistance. Pine Tree is a nonprofit organization that provides free legal services to people with low incomes and working class people throughout Maine. Senator Carney has asked Pine Tree Legal to share our perspective on LD 1766. Pine Tree Legal believes this legislation provides a critical opportunity for the legislature to improve Maine's justice system. It will advance the fair and effective administration of justice by ensuring that all matters that come before Maine courts are overseen by full-time dedicated jurists. And in so doing, and I want to focus on one particular aspect of 1766, but I agree with all the testimony that has already been provided about the many benefits of this legislation. But one very important thing that this legislation will do is it will finally bring an end to the practice of law by judges in Maine. Maine's Code of Judicial Conduct includes a broad prohibition on the practice of law, which reflects the reality that the duties of judges and attorneys are vastly different, and in fact, they are incompatible. Attorneys have a professional responsibility to their clients. It's often referred to as being a zealous advocate. An attorney's duty includes the duty of loyalty. That is to act consistent with their client's interests at all times. They even have duties to former clients and to prospective clients. A judge's duties, by contrast, are to act in the public interest, serving the justice system as a whole. I won't quote them here, but I will just tell you that the opening paragraphs of the preamble to the Judicial Code envision a role for jurists that is strikingly different from that of attorneys. And the prohibition on the practice of law in the Judicial Code at Rule 310 serves the overall goal of the code of providing an independent, fair, competent, and impartial judiciary. Maine Judicial Code contains this exemption, though, for probate judges. It's not based on this perception that ensure that ensuring the greatest public confidence in their independence, integrity, fairness, and competence is less important for probate judges than it is for all other judges in Maine. Rather, the carve-out is based on this presumed necessity that probate judges need to practice law because they are part-time, and they cannot live on their judicial salaries alone. By establishing all probate judges as full-time, we will eliminate that perceived necessity, and we will ensure that judges are able to focus entirely on their duties to the public interest in their role as jurists. In my written testimony, I provide a few examples of the many problems that the exception for probate judges to practice law presents. These are practical problems, these are ethical problems, and they undermine our judiciary. And I'd be happy to share any of them in response to questions. So thank you very much. I urge you to vote ought to pass on LD 1766 to allow Maine to finally take this important step forward to improving our system of justice for all the people of Maine. Thank you very much for providing an opportunity for Pine Tree Legal to testify, and I'd be happy to answer your questions.
I'll start with a question. Could you please provide us with one of the examples that is contained in your written testimony?
Yeah, one example. So I've been with Pine Tree Legal for about a year. In my past life, for more than 18 years, I was a faculty supervisor in the Cumberland Legal Aid Clinic for the University of Maine School of Law, and I supervised student attorneys there. And we had a case in probate court, and I'll give the short version of it, but as you'll see, even giving the short version, it's a little convoluted. We were appointed by the court to represent a mother in a contested minor guardianship matter. The petitioners, the people who had brought the petition, were the paternal grandparents. Their attorney ran for probate judge in the same court where our case was pending, and they won. So our opposing counsel actually unseated the judge who had been presiding over our case and issuing the initial matters. So because we only have one judge per county, our opposing counsel became the judge in the court where our case was pending. So obviously our case could not continue to be there. So what happened? We got transferred to another county. All of the parties, all the attorneys had to go to another county, an adjacent county, to be heard on that particular matter. But then we had a probate judge as our opposing county, the probate judge from the next county over. And, he shared with me very openly that he ran into the judge presiding on our case at probate judge assembly meetings. They were part of, sort of the emails chain where they're talking about procedure and substantive matters and best practices and so forth. When we were in chambers meetings, there was a different vibe. Needless to say that there were two colleagues there, and there we were. When we got very close to the final hearing, that judge finally withdrew from being the opposing counsel. He said he didn't think it would be right to be there for a contested hearing, although he had been involved in the case by then for months. But then he entered his appearance on behalf of the child's father. This was the son of the petitioners in a district court proceeding in the same county where he sat as probate judge. And so it was basically opened a second front against our client in a parental rights and responsibilities matter involving the same child against our parents. So we still had a probate judge as opposing counsel in the case, again, down the road, literally from where he sat in a room with a black robe. And our client and the student kept asking me, I don't understand how this can happen. I don't understand how this can possibly be, but it is entirely consistent with the carve-out in the Code of Judicial Conduct, and it's entirely the result of the way that our probate court system is structured and is stuck because of, this is how it was set up in 1855. And even though it was the main voters voted to change it in 1967, it has not to date. And this is exactly the type of situation, the ethical, the practical problems that will end as soon as we make all of our probate judges full-time.
Thank you. Are there other questions, committee members? Representative O'Halloran?
Thank you. This is all new to me and I'm trying to read it and catch up, but so if this passes, will probate judges still be allowed to continue with the practice on the side?
No, so the practice is allowed now under the Code of Judicial Conduct for the practical reason, right? Because the sense is, well, they're only part-time and they can't live on their judicial salary. So we have to let them practice law so that they have enough. But I think everyone recognizes that, I mean, the code would need to be amended, of course, by the court. Go ahead.
I have one follow-up question.
I want to make sure I'm answering your
Because
question.
I want to another clarify. So I guess my concern would be that if you're leaving a practice for 4 years, when you come back to it, you really aren't going to have a job. You're going to have to rebuild it. So my concern would be, and I don't do this for a living, but in some ways, my job is similar. Like if you're gone for 4 years, you've pretty much lost your practice. Are we going to lose really good people that want to be judges that will run for this, knowing that they're going to be gone for 4 years and will have to start from scratch to rebuild their business if they don't re-win their election?
That's a great question. So what LD 1766 would do and what the new system would do was it would have probate judges be appointed by the governor the same way all other judges are in Maine. So this becomes a career change essentially for an attorney. They would leave the practice of law and they would become full-time dedicated jurists. That's what we don't have now. We have judges who have sort of this divided attention and they have to run for office every 4 years. So your question is a perfect example of the reason why this reform is necessary, is to allow people to fully immerse themselves in the role of being judge without having to worry about either maintaining or returning to a law practice. So the many wonderful people who have joined our state judicial branch, who are in the district court, the superior court, and the Maine Supreme Judicial Court, these are all attorneys who have left the private practice to devote themselves to public service. And that's what we think probate matters should be overseen by people who have made a similar decision. Does that answer your question?
Other questions? I'm going to go to Representative Sinclair first and then Representative Henderson.
Thank you, Madam Chair. Good to see you again,
Good to see you.
Professor. Is it contemplated that if this passes, the new probate judges would remain fairly siloed in probate matters, or is it instead the idea that they would become part of the jurist pool where all of the jurists would get some additional training in probate matters? Those who had only been doing probate matters would also become trained in FEDs, PFAs, all, the litany of other types of cases. So what's the breakdown contemplated?
My understanding of what the commission had recommended, because I believe that this was something that the commission took a careful look at, is that they're not going to be as siloed as they are now. I mean, right now they are limited because of the jurisdiction that under Title IV to what probate courts can and cannot do. By being judges within the judicial branch, I think that limitation in their jurisdiction would be eliminated. They would be judicial branch judges. I think the idea is that there is value, at least as of now, to have judges who have whose primary jurisdiction is going to be overseeing probate matters. And I think it's anticipated to maintain that for some time. And that's the reason why they would be 8 dedicated judges and a chief judge who would be focusing on that particular matter. But I think by bringing these judges into the judicial branch, it does provide a lot more flexibility than certainly there's zero flexibility now, essentially, for that.
Representative Henderson.
Yes, thank you, Madam Chair, and good afternoon.
Hi, good to see you.
You outlined, I think, some concerning conflict of interest when it comes to probate judges actively practicing law. Are there scenarios right now where there may be appointed judges currently within the system that also practice law part-time?
No, they're not allowed to. So Rule 310 of the Code of Judicial Conduct
Mhm.
has an absolute prohibition. The only exception is, I think they can do non-litigation, non-adversarial matters for a family member, and they can represent themselves. Those are the only exceptions that are recognized under the Code of Judicial Conduct for every other judge in the entire state of Maine. But the whole code has a carve out for actually a series of rules in the Code of Judicial Conduct specifically for probate judges. And the reason there's a list of rules that don't apply to probate judges is because of the way things are structured, and partly because they're part-time and partly also because they run for office.
Okay.
So no other judge in the state of Maine, unless they are violating the Code of Judicial Conduct, no other judge in the state of Maine consistent with the Code of Judicial Conduct can or does practice law now.
Okay. And you said that's 310?
310,
Okay, thank
exactly.
you.
Any other questions? Senator Hagan?
Very much. It's just popped into my head. I hadn't thought of it till 10 seconds ago. So if this, excuse me, if this bill passes, then we bring the current probate judges into the judiciary. They do their trainings and all of that. Then they're put into the judge pool. Some places have hardly any cases. Some have massive amounts of cases. Would they be traveling judges?
So I think that that's another important reform and benefit of the structure that has been proposed in LD 1766, because right now we're fixed in this county by county system. So there are some counties that have very heavy probate dockets and there are some that are very light. The ones that are very light, they might only hold court a couple of times a month because of that. But that means there's very long delays for the particular matters. By having all of the probate judges and supervised by a chief judge within the judicial branch, that allocation of judicial resources can be done based upon caseloads, right? Based upon geography, based upon capacity. And that's going to make it put the judicial branch in a far better position to meet the needs of litigants.
Representative Caruso?
Madam Chair. Thank you. This is very helpful. So just to follow up on Senator Higgins' question, currently there are 16 part-time probate judges. And if I look at this, there are 8 state court regions. So they looking to condense 16 part-time probate judges into 8 full-time positions.
Correct, with a 9th chief judge of the probate court, yes.
So in addition to a program manager or whatever that position was.
That's right, program manager to oversee the
Project
transition.
manager.
Project manager, yes.
They're also going to hire a chief who is full-time overseeing.
Right, it would be one, yes, there would be a judge within the judicial branch who would have that oversight. It's similar to the chief judges who are now in the judicial branch. An important function that they have is scheduling and allocation of judicial resources. And so that's one of the things that we don't have under our current system. We have these 16 independent courts with no coordination and no allocation of judicial resources.
Thank you very much.
You're welcome.
Any other questions? Looks like we're all set. Thank you. Anyone else in the room to testify in support? All right, not seeing any. We'll turn to individuals online who wish to testify in support. If you're online, please raise your hand, your electronic hand, and leave it raised until you have an opportunity to testify. All right. Noah Wiley. Oh, Lori, I'm sorry. Lauren Wiley.
Good afternoon. Is my microphone working?
Yep.
Great. Thank you so much. Good afternoon, members of the Joint Standing Committee on Judiciary. My name is Lauren Willie, and I'm the Legal Director at Disability Rights Maine. I have been practicing in probate courts for my entire time at Disability Rights Maine for almost 9 years. I focus solely on adult guardianship matters, as do my colleagues here. I've also practiced in state and federal courts in my prior career. It is crucial for the purposes of judicial economy, due process, access to justice, and judicial ethics that probate judges be incorporated into the state judicial branch. Currently, probate court judges are part-time elected officials who also practice as attorneys because they're exempt from the rule, the general prohibition. The fact that judges are also practicing attorneys raise serious ethical concerns that, as far as I know, no one refutes. And I think others have said it better than I, so I'm going to move on to my next point. Another serious issue that LD 1766 will largely remedy is the inefficiencies inherent in litigating serious matters such as guardianships, both for adults and for minors, property rights, parental rights, using part-time courts. In my experience, even an uncontested guardianship termination can often take the better part of a year to be scheduled and to work its way through the courts from beginning to end. Mainors litigating in probate courts, they deserve full-time jurists to shepherd their cases to timely resolutions. LD 1766 will also result in centralized oversight and uniformity in the probate courts. Despite some collaboration, the real-world reality is that there are 16 separate court systems and 16 ways of doing things. This leads to inefficiencies. It sometimes results in needing to refile things because certain courts have their certain preferences. This in turn leads to more delays in the process. This can be confusing for seasoned attorneys, let alone pro se litigants, which I believe are largely the norm in probate courts. It also raises deep concerns about access to justice. The idiosyncrasies of the courts can create insurmountable barriers for people. One example is individuals under guardianship who communicate, adult guardianship I'm talking about, who communicate to courts that they might wish to end or change somehow their guardianship. This is supposed to trigger the appointment of an attorney for them. However, many individuals contact us at DRM who have made that communication to the courts only to be told that they need to make additional filings or complete forms that are not really required at the initial stage of the process. This can create, and often does create, an insurmountable barrier and gives individuals no practical way into the courthouse to have their guardianships reviews. Solving this issue in one case, in one court, does only that. There's no systemic fix because there's no centralization. This is one example that is in part a result of the fragmentation of the current system. LD 1766 will address a lot of these concerns as well as the issues raised by others. And for these reasons, we strongly urge you to pass this bill. And I'm happy to take any questions if there are any.
Thank you. Are there any questions? Not seeing any. Thank you for your testimony.
Thank you.
If there's anyone else in line who'd like to testify in support of this legislation, please raise your electronic hand. And there are none. We'll turn to individuals in the room who would like to testify in opposition. Please step up to the podium. All right, not seeing any. If there's anyone online who'd like to testify in opposition, please raise your electronic hand. Okay. There is one individual online. We're going to move you over, and then if you could please activate your camera. Mr. Bailey? Welcome, please go right ahead.
This is Anthony. So I just, wanted the probate court to be able to order parental rights and responsibilities for developmental disabled adults that can't take care of themselves as an alternative. And also be able to appoint a lawyer for their parents and also just mainly because, it should be able to order, if their parents should have parental rights and responsibilities for developmental disabled adults, the judges should be able to order that. There shouldn't be any, I think it should pass as amended. And add on because it would be good to have probate judges to do the same thing as a family division on for adults. The same thing as a district court for a family division, for adults that can't take care of themselves. Like such as ordering parental rights and responsibilities for adult children that can't take care of themselves, that has severe developmental disabilities, that need their parents, and also reunification and support reunification. I believe taking away the kids, the adults and stuff like that, that can't take care of themselves, taken away permanently from their parents, is not acceptable. And also, I think the parents should have parental rights and responsibilities, because that would help a lot of people out. And I think it ought to pass as amended and drafted. The bill should be amended and add on, drafted. Anything you could do, I highly recommend that to take this consideration. Very highly recommended. This would help a lot of people out, and it also give the parents the opportunity to have parental rights and responsibilities over their adult children that cannot take care of themselves. That would really help them, and it will help the parents and also other relatives that want to take parental rights and responsibilities over them as well. The adult children that can't take care of themselves. Thank you. And you have any questions?
Thank you. Committee members, do we have any questions? I'm not seeing any. Thank you for your testimony. Right, is there anyone in the room who would like to testify neither for nor against? Please come right up.
Thank you. Susan.
Welcome.
Good afternoon, Senator Carney, Senator Kuhn, and distinguished members of the committee. For a moment there, as I listened to some of the testimony, I felt I had been dropped in here from another planet. I am not here, and I at the discretion and the request of the chairs, I'm going to address the amendments. But I do have to tell you that I've been on the bench for 9 years. I once had the privilege of sitting at a horseshoe like you making policy. And some of the comments about what judges do and what they're ill prepared to do as probate judges have basically surprised me, because that's not my experience. That is not my experience. And I'm going to go quickly about the amendment, but I'm going to end with what I hope you will. I'm not going to, that we've talked endlessly about whether or not we should put the judges in the state court. I'm not here about that, but I'm here about, and all the misunderstandings that I've heard today trouble me greatly. And I would encourage any of you, I'm across the street, come to my court one day, come see what we do. And that's why I want to talk to you about leaving the staff on the county level. By the way, I'm not speaking for any register or any probate judge. I am free to speak. I'm among the first districts to be combined. I'm not running again. At my age, I think it's time for me to retire, and I'm planning to do so. So I have no self-interest in what I'm saying to you. I just want to share with you my experience. I do believe that probate courts, and I hope that we maintain this wherever they're located, whether they're at the state level or at the county level, we are nimble, we are quick, we make sure people are heard. I can tell you this, I can do an emergency guardianship within 30 minutes, and we do appoint counsel, and the county does pay for it. Just remember those things. I brought with me my deputy register. I don't know that you understand what the staff does. They don't just process papers. They're our team. That's my law clerk. So this proposal, and I'm just talking about the amendment, we'll give 2 new clerks to these new state probate judges and leave these folks to push papers around. That's not all they do. I think it's a terrible mistake. One of the criticisms, we haven't talked about, well, we did talk about inconsistencies, but it's the practitioners worry about that. You go to one court, you might get one set of treatment. You're going to have 16 independent registers. Who's coordinating them? And what is the point of that? What is the point of that? I would think you'd be doing the counties a favor. They might not agree with me. If you took the whole group, if you want a division of the probate court, which is what I read, like a business court, there's a division of the probate court, at least initially, bring the staff or what you need, bring the register, and Also, I want you to think about why you elect to register. It's a management job. You have an opportunity while you're repairing or making things better to deal with all of those issues. So I can tell you honestly, as a probate judge, I depend on my staff. They are law clerks. And I don't know how it would work for Somerset. You go there 1 week and you talk to their staff, which doesn't do what this staff does. You go to Kennebec another 2 days. It's all different. They need a chief leader as well. So it's just the amendment I'm speaking to. It is the will of this legislature and this committee, obviously, to decide what's appropriate, and I will do everything in my power to make it successful. I know my time's up. Don't mean to be a bad judge, but I need to tell you this. This morning, I mean, I want the advocates for the elderly to listen carefully to me. It's not where this court sits. There are no resources out there. The places we're sending our parents and our elderly, some of them you would not send your parents to. Today, I had a person under public guardianship in one of our licensed homes who almost died because an untrained nurse was giving lithium. He was so dehydrated they could barely bring him back to life. So they got him out and he's moved now. But we've got to have more resources. They come to me, families can't take care of them. They need a place to go because their needs are so great, but we can't put people in these homes that are failing us. If you want to know that story, next session, please work on that. So thank you. I'm sorry to go so long, but I really feel impassioned about what's happening to the elderly.
Thank you. Let's see if there are any questions for you. Any questions for Elizabeth Mitchell? Yep. Representative Lee.
Thank you, Judge. I'm kind of thinking about some of these ethics issues and the conflict issues that have been brought up, and I'm trying to understand why those folks who are still practicing as attorneys wouldn't be violating their bar rules by engaging in those cases that may raise a conflict of interest. And I don't know if you ever practiced at the same time as being a judge, but
Not very long. I'm fortunate to be retired, so I don't face that issue. I can understand people's concerns about the perception. But this is a way to handle it. Another way to handle it is have districts with a full-time judge. It has to be a full-time salary or people are going to have to do other work. It really isn't. I don't know if that answered your question. I apologize if not.
Any other questions, committee members? All right,
Thank you.
Annie, thank you for joining us. Anyone else in the room like to testify neither for nor against?
Hi, my name's Brielle Balmer. I am the Deputy Register for Kennebec County. I did not formally prepare any testimony, but mostly as a follow-up to Judge Mitchell's testimony about the close work between the registrar's offices and the judges, and concerns that I have as somebody who works within the office if that relationship was separated and our ability to serve the public. So in almost every county, I would bet at least 2/3 of our cases are cases that do not involve the judge. They are informal matters with the states where the register has the quasi judicial power to grant whatever that application is for. Again, that's the majority of the work that we do. There is a lot of inconsistencies between each register's process, and that is something that is allowed currently. There is no chief register. There is no set other than what is in rules and statute that the register has to abide by when making those decisions that the register makes on a daily basis and the rest of their office in turn makes. By pulling the judges to the judicial branch, that would resolve one end of the inconsistencies between what judges may do, but it's going to leave a lot of the inconsistencies that have to do with what types of filing will be accepted, because the judges are not the one who are physically accepting the filings, it's the register in their office. Along with different fees that are set. There are some fees in the probate code that are allowed to be set by each county right now. So if you file in one county in a state, your filing fee is going to be different versus at another county. there are a lot of things in our job that is more than just accepting in the filings. Like Judge Mitchell had said, we accept in the filings, we help assist with scheduling the cases. I personally sit in with almost every hearing that we have with Judge Mitchell. So I am taking in the filing, I'm talking with the people when they're coming to file, telling them what forms they need. I am the one who's sitting there listening to their hearings. So when they come in a week later and they have a question about, well, what did they say? What am I doing now? I know exactly what's going on in their case. My concerns is with separating these two things into different offices would be that my ability to serve the general public would be hindered, because there would be that lack of connection between the more informal process and the more formal process. And I'm available for any questions. Today, I'll be here at the work session as well.
Thank you. Any questions for Representative Crusoe?
Thank you. Thank you for being here. Thank you for this information. This may not be true across every county, but in your case, are there other aspects of your job that are unrelated to the probate court?
Not unrelated to the probate court as a whole, because the probate court right now does take in those informal, but it's just that the informal matters don't go before a judge.
Right.
The register has the quasi judicial immunity to do that. Other things such as scheduling, issuing the notices that they use, even in the things that the judge is the one handling, are duties of the register as well in that office.
What's the title? Registrar
Of probate.
Oh, okay.
Yes.
So that is a full-time job.
Yes. Yeah. And I am the deputy registrar. So there is an elected register. I am a hired employee of the county and I am appointed by the register out of that pool of employees in our office. Yeah.
Thank you very much.
Any other questions? Not seeing any. Thank you. Anyone else in the room who'd like to testify, neither for nor against? And if you're online and would like to testify, please raise your electronic hand and leave it raised. All right, we have one person moving over. Oh, Julie Finn. Welcome.
Hello. Good afternoon, and I apologize for not being there in person today. But hopefully I'm alleviating the crowds a little bit by keeping the chair empty. Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch. And I will provide some brief testimony, neither for nor against LD 1766. I'm going to skip the part of my testimony about the commission. I think Senator Carney already talked about that and about how we got to the place where we are with this bill. A lot of work has happened prior to today that you already know about. And just a few weeks ago, as you know, you held an informational session regarding this bill. State Court Administrator Amy Quinlan appeared before the committee, setting forth the position of the judicial branch at that time. Leadership of the judicial branch fully supports including probate court judges under its purview for all of the reasons articulated over the years back until 1967. As has been mentioned previously, the most significant reason is the appearance of impropriety when individuals sitting as judges are permitted to practice law in the communities in which they serve. As you know, taking on the probate judges will be no small undertaking. State Court Administrator Quinlan really mentioned three prerequisites to initiating the merger described in LD 1766. One, postponement of the date of implementation until January of 2028, with the first probate judges coming on board in January 2029. Two, the hiring of a project manager and possibly others well in advance of that date to conduct necessary planning and analysis. And three, ongoing fiscal support for the transfer of the judicial positions and the addition of support staff in future biennial budget cycles. The sponsor's proposed amendment that was circulated recently includes the postponement of the implementation dates as well as the new project manager position. Upon further review, the judicial branch will also need a position to assist the project manager coming on board about 6 months afterwards. This position, the title would be a process specialist, was included in our previous fiscal analysis when this bill came up a session or two ago, and is thus not an additional position, but one that will need to be hired earlier than anticipated prior to the implementation date of January 1, 2029. All other positions would be added in upcoming biennial budgets. That said, however, I would like to briefly mention that the position identified as the chief judge of the probate court would not be appointed until January of 2029. However, there is language in the bill that contemplates having the chief judge assist in the planning and implementation of the merger of the two court systems. For example, the chief judge would need to examine the status of dockets and caseloads to ensure a successful transition and avoid unnecessary delay. The chief judge will also need to assign judges, be involved in the assessment of courtroom facilities, and oversee the transfer and development of a guardian ad litem roster, for example. Some of this planning work will need to be accomplished prior to the date the chief judge comes on board under the language of the current bill. The judicial branch finance team is working hard to update the fiscal analysis that was done in conjunction with the bill that was considered 2 sessions ago. This fiscal note will extend out several years and include positions and costs that will need to be appropriated by future legislatures. We will have this document ready for the work session. That said, because this initiative is unprecedented, there will be costs that are unknown at this time, especially with respect to facilities. Physical space, technology, and security requirements will have to be carefully reviewed to create consistency among counties and court locations. Given the size and scope of the task of incorporating the probate judges into the judicial branch, we must be thorough and cautious in its development of a multi-step organizational plan. The transition must be smooth. We have to get it right. The rights of
Julie, could I ask you to finish up your?
Yep,
just
I'm pretty
a few
much
sentences?
finished. Actually, that was the end.
Oh, okay.
I will just quickly add that in addition to a fiscal statement, which I know you're anticipating, I will also have a planning schedule. I was hoping to have it today, but it's a planning that shows the dates of hiring and folks coming on board and the different types of work that will need to be done in advance of this bill coming on board. So I'll have that for you later as well.
Thank you. And can I ask, did you upload your testimony that you just provided? Or
I
could you?
did.
You did. Okay.
I did,
Thank
yeah.
you. Committee members, any questions for Julie Finn? Not seeing any. Thank you.
You're welcome. Thank you.
Okay, if there's anyone left who'd like to testify on this bill, please step forward or raise your electronic hand. All right, all testimony taken. We'll close the public hearing. Thank you, everyone. And we'll take a minute to turn the room over and invite folks who are testifying on the next bill to come join us.
Committee members, we're going to resume our work this afternoon. We're opening a public hearing on LD. So actually, no, we're not. We're going to do a couple things. First, committee members are going to reintroduce themselves because there are many people in the room who are new. And then Janet, why don't you address us first? Janet has an item with regard to the bill we voted on yesterday that she just wanted to call to the committee's attention.
Yesterday, as you know, you voted on LD 524 with the new name of an act to protect children from technology facilitated sexual abuse. As you know, the unanimous committee amendment proposes to create new crimes involving technologically assisted CSAM. And because the bill proposes to create new crimes and at least a majority of this committee voted in favor of it, under the joint rules, Joint Rule 319, you are required to send a memo and ask for a review of the impact of those new crimes on the criminal justice system. And that review will be conducted by the Criminal Justice and Public Safety Committee. I thought of that on my way home last night. So the chairs have already initialed a memo that will ask for that review. And because you added the emergency preamble, I've already talked to the analyst for that committee and mentioned that it might be helpful to do that review in an expedited manner.
Thank you, Janet. Any questions, committee members? We've done this with other bills as well. Okay, great. Janet, thank you for continuing to think about the bill on your drive home. And now we're going to do just a brief round of committee member introductions since we have a lot of new members of the public in the room. And Representative Sinclair, would you like to begin?
Thank you, Madam Chair. Good afternoon. My name is David Sinclair, here for the people of House District 50, the city of Bath.
Good afternoon, everyone, and thank you for your patience. I am Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good afternoon. My name is Danny O'Halloran and I represent District 20, which is the majority of the industrious city of Brewer.
Hello again, I'm David Hagan, Senate District 10, 12 towns surrounding Bangor and not Bangor.
Still Adam Lee. I still represent District 89, which is downtown in New Auburn for the time being.
Good afternoon. My name is Ellie Sato. I represent House District 109 from the beautiful town of Gorham.
Good afternoon. I'm Mark Babin. I represent House District 3, Northeast Aroostook County.
Good afternoon. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Good afternoon. I'm Amy Kuhn. I represent House District 111, which is most of the town of Falmouth, and I serve as the House Chair of the committee. Welcome.
Good afternoon, everyone. My name is Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and some of Scarborough. I serve as the Senate Chair of the committee, and I'll be chairing the public hearing on this bill. So we'll open the public hearing on LD 1761. And pardon me? Oh, thank you for pointing that out to me. Representative Pugh, would you like to introduce yourself?
Thank you, Madam Chair and Representative Babin. Good evening, good afternoon. My name is Dylan Pugh. I represent House District 114, which is part of Portland.
And just as a reminder for everybody to orient you where we are on this bill, this is a bill that originally had been referenced to health coverage, insurance, and financial services. That committee amended the bill significantly, and it was on its way to the chambers. We were requested to have the Judiciary Committee look at this as well as its overlapping jurisdiction. And also there was a request, and we thought that it was a good idea to have a second public hearing that focuses specifically on the amendment language that was voted on in HCIFS, because it's different enough that we really would like to hear feedback on the amended version of the bill. So that is where we will begin. Before I invite the bill sponsor up to present on the bill, I want to ask our colleague, Representative Poirier, to introduce herself. She's joining
Thank you,
us
Madam
online.
Chair. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Thank you. And is Representative Morris with us to present the bill? Okay. So we'll give him just a moment to join us. Yes.
Thank you. So clarification on the amendment in front of us. This was something that came, it's HCIFS committee amendment. Do we know who spearheaded this amendment?
It represents the work of the committee as a whole.
As a
I believe it received a very strong, if not unanimous, committee support.
Okay.
The it's we do have the voting
Oh, it
sheet
is
in the
unanimous.
folders.
Yeah, thank you.
And just to confirm, it did have a unanimous committee support. The ought to pass as amended motion. I'm going to turn that over to Co-Chair Kuhn. He's asking for jokes.
My mind is a blank. I can't explain.
As long as we keep the mics up. And those mics.
Welcome, Representative Morris. Could you turn on your microphone? Thank you very much.
There you go.
Welcome to the Joint Standing Committee on the Judiciary.
Yes,
And please present LD 1761 when you're ready.
yes. I know you have some written testimony from when I presented the bill to the previous committee. So I'll just refer to that. Senator Carney and Representative Kuhn and members of the Committee on the Judiciary this time. I am here to present LD 1761, an act to prohibit indemnification agreements. What this bill is about is restoring fairness in business relationships It protects small companies, independent contractors, and service providers from being forced to take on legal liability that rightly belongs to someone else. Under current law, it is not uncommon for a larger business to include a clause in a contract that shifts liability for its own mistakes, sometimes even intentional ones, to the smaller party in the agreement. These clauses are often buried in legal language and presented as non-negotiable. LD 1761 makes clear that these kinds of indemnification provisions are against public policy and unenforceable when they attempt to make one party responsible for another's negligence or intentional wrongdoing. No one should be held legally or financially responsible for actions they did not cause and could not control. This kind of risk shifting can have real world consequences. Small businesses with slim margins are placed in an impossible position and sign a contract that exposes them to unpredictable liability or walk away from a job they need to stay afloat. That is not a fair choice. It undermines accountability because the party most in control of the risk is no longer incentivized to behave responsibly. LD 1761 does not ban reasonable risk management tools. Parties can still require appropriate insurance, and the bill explicitly allows for naming someone as an additional insured. It also preserves the validity of workers' compensation and other insurance agreements. What it does is prevent abuse in situations where a powerful party uses its leverage to offload its own liability onto someone with less bargaining power. Thank you for your time on this. I'd be happy to answer questions. There are others coming after me that are certainly have more technical knowledge of this topic. I will say we worked on this in the insurance committee, and then we referred it up to you because there's a lot of legal issues that I know you guys are certainly better equipped and have better experience dealing with than we do in the insurance committee, at least with some of the more technical aspects of it. That's why even after we did kind of come to some agreement, there were still some more concerns and questions, and that's why it's being referred to you. And I know you have plenty to do, so.
Thank you very much for presenting the bill. I want to ask you or give you an opportunity if you'd like to comment on the amendment
Yes,
language.
the amendment, yes, this is something that, again, trying to get to the heart of like exempting things like recreation and other issues that we're not trying to, I think one of the examples that was raised or concerns that was raised was about like a ski resort when you get a lift ticket, or some of these other issues. We want to make sure that that's not something that we're trying to nullify with this type of law. We're trying to really get at sort of the small companies that are bidding on contracts and those types of things is what we're really trying to get at the heart of. And it's just about trying to find that proper language as is in the amended version and possibly further amendments. So.
Thank you very much. Committee members, are there questions for the bill sponsor? Yes, go ahead, Representative Lee.
Thank you. Thank you for presenting today. And if this is a question you want someone else following you to answer, let me know. I'm trying to read the language of sort of the general rule and then the third subpart C exception. And I feel like the general rule is super broad, and then the exception is also super broad.
Okay.
And so to the point that it's almost like the exception swallows up the general rule. And am I missing something in the generation of that last exception?
I think, I mean, I think that's certainly something that folks coming after me can better definitely, but I think this was one of the things that we certainly struggled with. And again, I think we all understand what we're trying to do is help small business, but not absolutely make, we want to make it easier for smaller businesses is really the genesis of this bill. Yep.
Thank you. Other questions, committee members? I'm not seeing any. Thank you very much.
Thank you.
The first person who wishes to speak in support of this legislation, please step forward. Welcome.
Thank you. Copies of.
You can just put them in the basket right next to you. Thank you. Please begin when you're ready.
Senator Carney, Representative Kuhn, members of the Judiciary Committee. My name's Joe Edwards. I'm here on behalf of the members of 7 workers' compensation self-insured trusts. Really, this is sort of David versus Goliath. I'm also here on behalf of David, just to make that clear. Representative Moore's presentation, I think, conveyed the meaning of the bill and its purpose. In plain language, it requires people and companies to be responsible for the harm that they cause negligently. That's it. If someone causes negligent harm or damage, they should be accountable. My members believe this standard of responsibility should apply equally to everyone living and working in Maine. And for the most part, it does, except when large organizations contractually use their economic leverage to bully smaller companies into accepting responsibility for the larger company's negligence. That result is plainly unfair, and I would submit is fundamentally inconsistent with basic principles of justice and accountability. It goes to public policy. There's a rumor that there may be some objection to this bill and opposition. We'll see. If there is, I would suggest that you ask opponents 2 questions. First, will they be responsible when their negligence causes injury or damage? Simple yes or no question. And secondly, how often have they willingly accepted responsibility for someone else's negligence? How often have any of these opponents themselves accepted unlimited liability for someone else's negligence? In my 50 years of legal practice, much of which has been in contract law, it's a serious red flag when one party demands something of the other that it would never consider doing itself. What you have here in the end, and I'll summarize quickly. On one side, we've got mid-market, Maine-based, many family-owned, smaller companies whose issues here are matters of principle: accountability, responsibility, fairness, safety. On the other side are large organizations that can bully them into accepting responsibility for the larger organization's negligence, thereby insulating themselves from the consequences of their own mistakes. We don't think that's fair. We don't think that's good public policy. And in the negotiations and conversations I've had with opponents, it's never been about principle. I haven't heard from them principles of fairness and equity and justice. What I hear is it's expensive, it's a nuisance, it's a hassle, it's complicated. They may have serious, significant issues, but if they do, those should be addressed specifically. Insulating them from the consequences of their negligence should not be the answer. And certainly putting that liability on an unwilling other party should never be the solution. So for those reasons, I respectfully urge the committee to support 1761. Thank you.
Thank you very much for your testimony. Let's see if there are any committee questions for you. Committee members, are there any questions? Yes, Representative Henderson.
Thank you, Madam Chair. I have a few. I'll just start with one and then open it back up to the committee. I know we had an informational session at the end of last year, and so I'm kind of like trying to re-whet my appetite and remember insurance policy, which is something that we don't really tackle here. We tackle everything else, just that's the one thing that we don't discuss here in this committee. Can you give me 1 or 2, or maybe for the sake of time, just one real world example of the problem that's in front of us and what we're trying to fix?
I think there are 2. I'll make it quick, but I think there are 2 examples that'll demonstrate the wide range of what the issues are. First one, I came across this early in my career here in Maine. One of my members was asked to sign a contract with a large national corporation. I reviewed the contract and it was one of these covenants. The small company in Maine was to be held liable for the large corporation's negligence. It was unacceptable, non-starter. So I said, Bill, can't sign this. He said, well, what am I going to do? I said, go back to the manager that you're negotiating with and tell him this is unreasonable. He did. Manager said, hey, this contract came from corporate. There's nothing I can do. You've got to talk to the lawyers. So I ended up in a conversation with two senior partners of a New York City law firm, big guns that were the national legal representatives of this big corporation. That conversation lasted less than 2 minutes. It was immediately obvious that they had no interest or really ability to modify that contract. Their job was to protect the company. So those covenants were going to be included because they could be, and they had no reason to withdraw them. They didn't care about fairness. They didn't care about reasonableness. They just said, no, we're not going to do it. Fortunately, this being Maine, I had a friend who'd gone to college with one of the senior VPs of this big corporation. He got me on the phone with him. Now, this was somebody I never would have been able to talk to otherwise, way beyond my pay scale. But I talked to him and I explained the situation. He said, we don't do that. That's ridiculous. It's completely unreasonable that this big company would ask this small company to accept its liability. I said, well, would you look into it? A couple of weeks later, he called me back and he said, we don't do that anymore. And the lesson was there, if you can get the people senior enough in some of these companies that care about have the perspective and understand the reasonableness and the ethics and have some concern for the company's reputation, you can make some progress, but not with the attorneys and the HR people whose job it is to protect the company. And that's who you're normally negotiating with. Second example is big corporation has a big parking lot. Lots of parking. It's Maine, it snows in the winter. I can tell you from our comp cases, the highest frequency injury for work-related comp cases in Maine during the winter is slips and falls on the ice. It happens. It's almost unavoidable, although we do the best we can. So this big company hires Joe Edwards plowing, one truck, one plow, and maybe they hire 3 or 4 of these individual standalone companies to do the plowing. Inevitably, somebody falls. But the corporation, the owner of the parking lot and the big corporation is completely insulated from any liability because they've got this hold harmless. If they negligently hired the truck, didn't provide standards, didn't provide supervision, all the allegations you might make against the company get turned back onto this plow truck driver who may have $20,000 of equity in his truck. And that's all the claimant can get. The claimant sings for his supper because there's no way to recover against this judgment-proof, isolated individual. Now, those are the most egregious and classic examples. I use those because they're instructive. That's not the norm, but that is what happens. Those are real cases.
Thank you. Do you have follow-up questions, Representative?
Yes, I do. And so, thank you, Madam Chair. You're talking about the negotiation piece. That was another one of my questions is why can't these types of agreements just simply be negotiated? And what you're indicating is that because the people that truly care about this issue are not the ones that are actually negotiating it, that it seems to be more of a legal counsel or?
Well, in some cases, I mean, first of all, and for these big companies, most of them aren't based in Maine.
Mm-hmm.
Some are, but most aren't. And you don't get to the senior officers, the C-suite officers to kind of discuss this. And it would be beneath their interest level generally anyway. But the lawyers, part of the reason these things are proliferating now is because the attorneys have realized that they can do it. So they have to do it. I mean, it's almost malpractice. If your assignment is to protect the company and that you can put this covenant in, you have to. So they end up in more and more contracts, and there's really no give because the lawyers, they do it because they can, and therefore they have to. And the fact, I mean, no one voluntarily signs these covenants willingly. I mean, is there anybody here that's willing to take unlimited responsibility for the results of my negligence? You wouldn't do it. Nobody does it. The only way it happens is under duress, either ignorance or more or less desperation. Otherwise, it doesn't happen. So you've got people bullying. It's the bullying that does it in the first place. So they're not going to back down. They've got the economic leverage and they can force it. It doesn't happen in contracts where there's equal bargaining power. Because if they need each other equally, the target party can say, no, we're not going to do it. It's only when you can bully somebody that it happens at all.
Thank you.
Are there additional questions, committee members? Yes, Representative Lee?
I'm certainly usually a fan of siding with David in his battles with Goliath.
I didn't know that.
But I'm struggling with interrupting the right of parties to contract. And I can think of plenty of examples of instances where it would be legitimate for one party to assign their risk to the other party, even in an equal bargaining or unequal bargaining relationship. But so how do we evaluate when a relationship between two bargaining parties is so unequal that it requires legislative intervention?
Well, first of all, our proposal is global. You don't have to make that evaluation. It would be the public policy of the state of Maine that it is unacceptable, unenforceable to convey liability for your negligence to another party. So, but the issue, I think the issue you were touching on is the normal hold harmless in a healthy contract is I indemnify you against my negligence. If I do something negligently, you will not be held responsible. And you likewise indemnify me against your negligence. That's symmetrical. It's balanced. These covenants are not that. This covenant is, I say to you, you're going to be responsible for my negligence. And we just think that's, I mean, we talked about this in my various groups, and most states have dealt with this in construction. Maine has dealt with it in transportation. There are some targeted issues. My boards, 7 boards of the 7 trusts, all voted unanimously that this is just wrong, that the policy of the state of Maine, in their view, should be you cannot transfer responsibility for your negligence. The workers' compensation trusts that we run are extraordinarily successful at reducing claims for 2 reasons. Self-insured, they pay with their own money. And 2, they've come to realize that safety has to be more important than anything else. And those 2 are connected. So when you divorce from somebody's liability, there was the payment, they're not going to have to pay. There's a diminution of their concern in safety. And that's something we think needs to be connected to make sure that people are safe.
Go ahead.
Is there any other state that does it universally like this?
I don't think so, but I don't know.
Additional questions, committee members, Representative Henderson?
Thank you, Madam Chair. So I think my last question, you know, today's the first day of the legislature. Apparently indemnification was a big issue because walking through the halls on the 3rd floor, I was greeted by many people who wanted to chat with me about indemnification. And I'm sure many of you were too. And the majority of what I heard is that this is overbroad, this scoops in way too many people, that this could effectively be a real problem. Kind of scanning through what other states have done, it seems as though other states have adopted, maybe not on the majority, but there have been states that have adopted more of a narrowly tailored to a specific industry. So my question for you with that, in light of that, is, would you be open to some form of a compromise where we do narrowly tailor this to a certain industry, a certain type of contract? And if so, would you be willing to work with us to find that compromise?
Well, I'm here on behalf of David. So we have a slingshot. You have all the authority. Of course, we'll work with you on whatever it is you think is appropriate. I mean, we've brought this to you. It's now your bill to act on. My members strongly feel that this should be the broad public policy, that there is no reason to exempt someone from responsibility for their negligent acts and the injury that causes. Now, negligence is the breach of a duty of care. So there are people and groups to whom one does not have a duty of care. Trespassers, in Maine, recreational users of open land. So if people come up here in opposition, we think the better solution is if they've got a legitimate reason to have some problem resolved or be exempted or have a group not owed a duty, then that's what you should do. I mean, that's your job and your judgment. But we don't think that they should be exempted in a general way in any activity from responsibility for harm that they caused through negligence. I mean, you can exempt people, you can solve problems. We tried to do that with a number of people who are allegedly opposed to this. But at the end of the day, the one thing we think is critical is that people are responsible for the consequences of their negligence. And that's the one thing that the people we met with refused to accept. And it's understandable. I mean, that's a great blanket protection. It's fabulous for them. No damages, no worry about safety, no duty of care. They don't have any concerns. It's all offloaded onto another party. But that only happens through bullying. And it's fundamentally wrong whenever it does. That's our position. If you need to I mean, I've been around the legislature for 40 years. I understand political needs and doing the possible and not making the perfect the enemy of the good. So we'll work with anybody in a reasonable solution, but we want to very strongly take the initial position that we think you should make it public policy that people are responsible for their negligence. It's generally true for everybody. Why not here?
Thank you. Any additional questions? Yes, Representative Caruso.
Thank you, Madam Chair. Thank you for being here. Thank you for your two examples. I was just curious if you have a way of expressing how widespread or how infrequent this sort of situation is where you described that one client.
Well, two things. It does come up in the comp trust work where somebody will cause injury. And so if our member has signed one of these covenants and they go onto somebody's property and are negligently injured by the property owner or the corporation, normally we'd have a right of recovery and we'd sue to recover from the negligent party that injured them. Where there's a hold harmless there, we're barred. So we can sue our member, which we probably don't usually do, but if it's egregious enough, we might, or we have to just pay the claim. That happens with probably a frequency of a few times a year where that happens. Maybe some years not at all, some years 2 or 3 times. But coming behind me are real business owners who are dealing with this, and it probably give you a much better idea of how frequent it is and how much of an issue it is for them.
Thank you. Other questions? Yes, Representative Sinclair. And then Mr. Edwards, will you also be present at our work session?
If you want me there, I'll be there.
Okay,
Yes.
thank you.
Yes, Chair.
Go ahead, Representative Sinclair.
Thank you, Madam Chair. I'm trying to understand better your bullying argument because I am normally sympathetic to that kind of argument. But aren't we talking here about two parties that are free to contract or to not contract? Is there anything compulsory about their joint entering into these contracts? And if not, why can't the smaller entity that you're saying you represent, why can't they simply say, I'm not doing this. You either remove the indemnification clause or I'm out.
Great question. Absolutely. And perfectly well stated. So think about that for a second. What happens? Somebody, big box store wants to have a build out. It's a multi-million-dollar contract. There are 4 or 5 contractors for whom it's a make, 3-year project, full employment growth and everything else. It's a tremendous benefit. And there are several of them competing for it. And one of them has the integrity and the legal knowledge and the intelligence to know that they shouldn't do this. Well, okay, but then their competitors, whoever's either not well advised or uninformed or desperate or willing to gamble will take a risk. And so you'll see from the people that come in, it's economic necessity in some cases, ignorance in some cases, and competitive forces in some cases that makes this happen. The fact that it happens is the proof of the bullying, because no one well-advised and responsible would ever agree to accept unlimited liability for a large organization. You just wouldn't do it. And anybody that signed it and understands it will either say, I didn't know, or yeah, but I had to take a chance. And the risk is, if there is serious injury, that business can go under or be damaged, and or the claimant might not be able to recover because of the limited resources of the person who's ultimately liable rather than the one who is negligent.
Thank you. Other questions? Yes, go ahead, Representative.
I find this very interesting. I've dealt with actually some of this in the work that I do. And I know, or I'm not sure how to word this in a question, but sometimes the corporations can also be on site and directing them to do things that the owner of the company that was hired to do it isn't even there or aware of.
Another great question. Absolutely. And so I think you may hear from some of the opponents, the idea that, well, if it's take the big box store and a build out, the construction company is going to be on site. The contractor will be there. The owner of the big box store may be in Philadelphia. They're not there. They say, look, these are the people best able to manage the job site. And that's absolutely true. That, however, has nothing to do with the negligence of the owner. If the owner did something that was negligent, violated its duty, that's not on the contractor. Now, the contractor may see it and save the property owner from that consequence. But if he or she doesn't, and it's still the negligence of the property owner, that should be their liability. The fact that they're on site, they're going to be responsible. And I mean, this is what a tort case is. And this is what a negligence case is. You come to court, who did what, there's contributory negligence, there's assumption of the risk, there's last clear chance. All of that gets litigated as part of this. But that should not insulate either party ever from the consequences of negligence that causes harm.
Thank you.
Yeah, I'm not seeing any other questions. Thank you very much for your
Thank you.
testimony and answering all of our questions. Would the next person who wishes to speak in support of this legislation, please step forward and welcome.
Thank you.
If you'd like to begin now, you may. You don't
Absolutely.
have to wait for the paper to be
Nope, that's
distributed.
fine. I'm going to
but you
paraphrase.
can.
I'm going to paraphrase a little bit so to not repeat anyway. So.
Okay, thank you and welcome.
So Senator Carney and Representative Kuhn and the members of the Judiciary Committee, thank you for being here today. My name's Larry Grondin. I'm the president of R.J. Grondin Sons based in Gorham, Maine. We're a fourth generation family owned business. We do heavy earth work, a lot of DOT work, MTA work, commercial site work from basically Waterville down south to Kittery. So try not to, I'm going to go down the rabbit hole from the construction side because we see a lot of, that's what we do and we see a lot of contracts. So I'm not a lawyer by any stretch of the imagination. So I do appreciate Representative Lee's question on, it seems very broad, but then number two seems broad. I wish I could answer that question, but we do see contracts that are just trying to push liability down onto us. So we're often a subcontractor to a general contractor for a big building. So we've been around long enough and we've got enough horsepower that we do negotiate these out, and very seldom do we just walk away. But the biggest thing is it's a function of fairness. What's fair? We're in a very safety sensitive industry. Everything we do is dangerous. We work around 90,000 pound machines. We dig 10 feet in the ground, putting pipes in. So everything is very safety sensitive. We've been 7 years without a single injury where somebody lost a day of work. So for that's 2 million hours worth of work. We're super proud of it. We take ownership in it. And the simple fact is, if somebody we're working for and we have a bad contract, tries to push that down on me, I can't control that. So if they have a bad safety culture and I can't control it, but I have a bad contract, well, then that comes down on me. And that's not what I want. And I know I'm being very specific to construction. I do agree with Joe that, this should be good for everybody. What? And maybe it doesn't work. I don't know the legality of that. I do know that transportation has set up very similar thing for quite some time now. In my understanding, there's really been no unintended consequences. So it just seems to me that this is long overdue, honestly. And I pretty much said that in my testimony. So again, not trying to reiterate and repeat, but I said everything in my testimony and added to it.
Thank you very much. Committee members, are there questions? Oh, yes, Representative Lee.
You referenced a couple of examples, or you said generally, and I'd kind of like to get a little more information on those examples of the instances in which you've been able to negotiate out these provisions and sort of the natures of the companies that you.
Yeah, so we do some larger contracts. So we're working for a national firm right now. And also a national GC. They're based out of Missouri. Never worked with them before. So, and the opposite of that is we work with local contract GCs and have a master contract. So when we get a contract, it's literally 1 page because we have this 10-page master thing that we all agree with. So we're not reinventing the wheel every time. So when we deal with a firm we've never dealt with, often, not always, but often they're trying to push some of their liability onto us. Well, we've done this long enough that we'll say, here's our red line copy, here you go, and you negotiate back and forth. But not all companies are that savvy. Maybe there's a financial, oh, I really need this job, and I'll look the other way and hope the best. Well, I don't do that with my 401k. You shouldn't do that with your contracts either. So.
Additional questions, committee members? Seeing none, thank you.
I appreciate your time.
We're going to hear from one more person speaking in support, and then we are going to take about 5 to 10 minute break just because we've all been sitting here for several hours. Come on up and provide your testimony.
Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Catherine Robbins Halstead. I am here today on behalf of Robbins Lumber Company in Searsmont and East Baldwin, Maine, a family-owned manufacturing business that has operated in the state for 6 generations. We employ over 200 Maine people. We invest in Maine communities, and we work every day to keep our employees and job sites safe. I'm here to urge you to support LD 1761. Last year, the boards of 7 self-insured workers' compensation trusts in Maine, including the trust our company belongs to, Forest Products Group Trust, came together to support legislation that would prohibit a deeply unfair and increasingly common business practice, forcing one company to accept liability for another company's negligence as a condition of doing business. Typically, this happens when a large corporation requires a smaller company to sign a contract that transfers liability for the larger company's own negligence onto the smaller company. The smaller company has little bargaining power. If they want the work, they must sign. That is not free market negotiation. It is economic bullying. As a result, Maine employers who did nothing wrong can find themselves financially responsible for injuries they did not cause, at job sites they do not control, arising from unsafe practices they did not create. This risk does not disappear. It is simply shifted onto smaller businesses, their insurers, and ultimately their employees. Maine already recognizes that this practice is wrong. We prohibit it in transportation contracts. Many other states prohibit it in construction contracts. LD 1761 simply extends this basic principle of fairness more broadly. At Robbins Lumber, we take workplace safety seriously. Like most Maine employers, we work hard to prevent injuries, but we also believe strongly in accountability. If our negligence causes harm, we should be responsible. That responsibility creates a powerful incentive to invest in safety, training, and oversight. When liability can be contractually transferred away from the negligent party, that incentive is weakened or eliminated entirely. That is bad for workers, bad for safety culture, and bad for Maine's economy. LD 1761 does not protect careless companies. It does not eliminate responsibility. It simply ensures that the responsibility rests where it belongs, with the party whose negligence caused the injury. That is the standard we live by at Robbins Lumber. It is the standard most Maine businesses live by, and it should be the standard for everyone doing business in this state. I respectfully urge the committee to support LD 1761 and allow it to move forward. Thank you for your time and for your service to the people of Maine.
Thank you for your testimony. Committee members, are there any questions? I am not seeing any. Thank you. And we will return. Please, everybody be back in your seats at 4:35. That gives us a little bit more than 5 minutes. Thank you all.
Yeah, perfect. All right, thank you.
Committee members, if you could please return to the horseshoe. We're going to resume the public hearing on LD 1761. Please begin when you're ready. No, it is not, but if you reach in front of the podium, you'll see a little button. Thank you.
Okay. All right. Good afternoon, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on the Judiciary. My name is Dana Duran. I'm Executive Director of the Professional Logging Contractors of the Northeast. We're an educational nonprofit that educates the public on logging and trucking issues throughout the Northeast, predominantly here in the state of Maine. Our membership, we have about 210 contractor members here in the state of Maine, and they represent about 80% of all the timber that's harvested and trucked in the state of Maine is done by one of our members. So I'm here to testify in support of LD 1761 on behalf of our membership. So this bill would make a much needed change in statute, which is of great importance to our industry. For decades, the lack of clarity on this issue has precipitated unfair practices to be included in contracts that force one party, often a smaller business or contractor, to take legal and financial responsibility for the negligence of who they may be contracted with no opportunity for recourse. As an example, when a logging contractor enters into a service agreement with a landowner or land management company, they may be required to sign an indemnification or hold harmless agreement. Such agreements typically hold the contractor financially responsible for negligent or intentional actions committed by the landowner or land management company. Attached to my testimony is actually sample language from a contract we received from one of our members. It's actually a current contract that is currently in place between a contractor and a land management company, but we've removed the names of the parties just to protect confidentiality. If you take a moment to review the document, the indemnification clause clearly articulates its intended scope and purpose. Indemnification agreements are unfair and shift the risk from the responsible party, the contractor, who has no control over the negligence of who they work for. These agreements are concerning because small independent contractors often lack the bargaining power to negotiate with larger companies and may be pressured into accepting terms that would shift liability and expose them to significant financial risk. This has been an issue for timber harvesting contractors for decades, and it's time to rectify it in the law so that this preponderance of control cannot continue to be precipitated. We respectfully urge the committee to vote ought to pass, and I'd be happy to answer any questions.
Thank you very much. I have a question for you about the attachment.
Yep.
Where there are the letters capital L, capital O. Is that supposed to be the
landowner?
The landowner. Thank
Yep.
you very much.
Yep. Yep.
Appreciate that clarification. Committee members, other questions? Yes, Representative Sinclair.
Thank you, Madam Chair. Good afternoon. You mentioned a lack of clarity, but I'm not understanding where the lack of clarity is. Isn't it instead that the issue is clear, that they are permissible, but that you'd prefer they not be? Or am I missing something?
No, I think that's a fair assessment. I mean, clearly, if you look at this contract, it's pretty darn clear as to what the expectation is. So I think from, our members' perspective, again, they have no bargaining power. They're at the bottom of the food chain. They literally are told you sign it or you don't work. And that's the situation, and that's been commonplace. So I think that's a fair assessment on your part. Yes.
Additional questions, committee members? Representative Lee?
Thank you, and thank you for being here. I'm trying to understand if there's any supports that you're providing to your members as regards the existence of these provisions in contracts. For instance, hey, be on the lookout for these provisions, and here's the things you can do to attempt to negotiate them out.
It's a fair question, Representative Lee. I mean, we're asked all the time by our members, what can I do? And we have literally, there's not much you can do. I mean, you can accept it or you can not work. And when you live in a very rural area, let's just say, we'll just use, for instance, you live anywhere in Aroostook County for the most part. And I'm not singling out Aroostook County. But if you're in the business of logging, you have very few choices as to who you go to work for. And so you are kind of at wit's end. You either accept it or you get out of the business or you leave and go somewhere else. Those are kind of your life's choices in these circumstances.
Go ahead with your follow-up.
Have you previously pursued a similar piece of legislation? We know that this exists with transportation, perhaps a similar piece of legislation specific to the logging industry.
On this specific issue? No.
Any additional questions, Representative Henderson?
Thank you, Madam Chair. Of your members, do you have, maybe not so much examples, and this might be better for the work session, if you could poll your members to see how many have turned down work? And of those that haven't turned down work, have been held liable for the negligence of a landowner?
I think I'd have to get back to you to survey, to your point. To give a specific example, if you'd like one, let's just say that, you know, a logging contractor goes to work for land management company or landowner. There's a logging road and a bridge that's been built, put in place prior. Contractor was told that it's safe to use, rated up to 150,000 pounds, 120,000 pounds, safe to use. Logging contractor starts trucking wood, that bridge goes out, whether it's because of their log truck or there's a pedestrian that's going across in a vehicle, it gives out. Who's liable in that situation? Is it the contractor? Who does the pedestrian, if the pedestrian's involved, who do they go after? They go after the logging contractor. The logging contractor has no recourse because they signed this agreement.
Right.
There's one specific example. We can give more.
Right, yeah, and I appreciate that, and I'm, at least for myself, I think I understand the scope of what we're trying to accomplish. I'm now kind of shifted my mind into the data piece, trying to be a little bit more data driven and how much work has been turned down and if work hasn't been turned down. If that is information you can get for the work session, that'd be really helpful.
Be happy to.
Thank you.
Thank you.
Additional questions, committee members? Yes, go ahead.
Thank you. So similarly, I was looking for an example, so that was a good example. Similarly, do you have an idea of how many times how often this happens? Is this a very rare thing where, not necessarily where they're signing an agreement, but where the larger corporation is negligent and pushes that liability and the cost onto the person that they signed the contract with?
It's a valid question, as was Representative Henderson's question, but Representative Brewster, directly to your point, I think, you know, I'd like to survey our members and get some data for you so that I can, you know, have statistics for you rather than anecdotes. Yep.
Anything else, committee members? Seeing none, thank you.
Okay, thank you.
The next person who wishes to speak in support of 1761, please step forward. Welcome. You can just put your extra copies in the basket. And you can begin if you'd like, or you may wait for your testimony to be distributed.
Senator Carney, Representative Kuhn, and the members of the Judiciary Committee. My name is Joseph Costello, and I'm here today as the Vice President of Bancroft Contracting Corporation in South Paris, Maine. Bancroft Contracting is a second-generation, family-owned, self-performing general contracting firm that has operated in this state for nearly 50 years. We specialize in industrial and heavy civil construction. We employ over 150 Maine residents and wake up every day focused on keeping our employees and our job site safe. I'm here to testify in support of LD 1761. In the construction industry, indemnification clauses are not theoretical. They are a regular contracting obstacle with real-world consequences, and we face them every day. At Bancroft Contracting, we are often compelled to sign contracts with indemnity provisions that make us legally and financially responsible for the negligent acts, the unsafe conditions, and the professional errors of others on a project. And at this point, I think it'd be more beneficial to the committee to talk to some of the examples that you're seeking rather than continue to talk to my testimony that others have covered. The committee has asked some great questions about how are these compulsory, and there's a number of ways they are for us. We're faced with purchase orders that get reduced to contracts that reference terms and conditions that are not on the face within the document. They're referenced and incorporated through that reference on websites that through various layers of selection and sophistication, you can only find them if you have the knowledge to go looking for them beforehand. So that creates that imbalance from start. Additionally, we are faced with situations where in our line of work, which is heavily specialized, there's not an abundance of work opportunities. We work in pulp and paper, we work in manufacturing, we work in marine construction. And if we're going to keep our workforce busy and gainfully employed, we have to evaluate whether or not there's situations in which we can accept terms that we know are bad for us. If we don't, the work doesn't go to other main contractors. It goes to out-of-state parties who don't have a long-term interest in the well-being of the main workforce. So they take the risk, and it creates or promotes a race to the bottom with respect to how we approach these situations. If someone is willing to take it and we want to keep our people working for us, we have to contemplate situations where we can accept those terms. Ultimately, this puts us in a position of fairness and responsibility, and it creates hazards for the main workforce. And I appreciate this committee taking this up today.
Thank you very much for your testimony. Committee members, are there questions? Yes, Representative O'Halloran.
Hi, thank you for coming today. Can you tell me, is it easier for, these big corporations that are hiring these contractors, if it's easier to track down and hold accountable a company from Maine versus a company from out of state?
I'm not sure that I can speak to that. I'm not sure if they can't track down and hold those companies accountable. In my opinion, it's that those other companies are willing to take risks that Maine companies that are entrenched with the Maine economy have to place greater considerations on.
Because of higher income levels, do you think? Or that they have more disposable income to take risks?
That might be a part of it, but I'm not sure that's the reason. For us, it's that there's work that's available locally.
Right.
And if we turn that down, then we have to look for work in states like New York or Wisconsin or elsewhere. That pulls our people away from their families, and ultimately it might lead to their departure from employment.
No, I am familiar with families and businesses and the struggles here, and I agree with that. Thank you.
Other questions, committee members? Seeing none, thank you.
Thank you very much.
The next person who wishes to speak in support, please step forward. Welcome.
Thank you. Good afternoon, Senator Carney, Representative Kuhn, members of the Committee on Judiciary. My name is Brian Park. I am the President and CEO of the Maine Motor Transport Association and a resident of Brunswick. The association is comprised of more than 1,900 member companies whose employees make up a large portion of the almost 34,000 people who make their living in the trucking industry in Maine. In an effort to not duplicate my testimony from the first regular session in the HCIFS committee, I have provided that testimony at the end of my written comments and would point you to some of the highlights, including why this is important to MMTA members, the fact that similar legislation, as has been referenced throughout the session today, is already in Maine law dealing with transportation contracts, and how this unfair practice employed by large corporations against small Maine businesses has impacted real people with a real example provided on the last 2 pages. I know that's been a question for many of the people today. We actually have a real example at the end of my testimony. I would like to use my time before you today to talk about dispelling some of the misconceptions that were brought up at the end of last session that halted the progress of the then unanimous committee vote in HCIFS. And probably the biggest misconception was that this bill would limit all indemnification agreements and that these provisions are needed to limit nuisance lawsuits. The way we see it, there are 2 different issues at play when this argument is used. The first is that should this bill pass, indemnification agreements are still allowed except in the case of negligence. Should LD 1761 pass, provisions in contracts that pass the negligent party's liability onto others would be unenforceable, and that provision in the contract is void. If you want to specify that this doesn't make the entire contract void, we would support that amendment. But the specific intention behind this bill is to have negligence retained by the negligent party and not be able to be handed off contractually because of one party's leverage over the other. The concern that this bill will encourage nuisance lawsuits, we see as a red herring. Not all contracts have indemnification language, and there are plenty of them that do have indemnification provisions in them, with the exception of negligence. At MMTA, we're not lawyers, so I can't say with authority that the occurrence of nuisance lawsuits is zero, but if it were a problem, this committee would likely know about it. And if there is a problem with nuisance lawsuits in Maine's judiciary system, that's a completely separate issue from indemnification provisions and points to a systemic public policy problem. Finally, and I know my time is running short, we do have a couple of amendment recommendations for you to consider. The first is the title of proposed Chapter 201B that currently reads Transfer of Liability Provisions in Contracts Prohibited. We would recommend replacing it with Transfer of Certain Liability Provisions in Contracts Prohibited, because the only contractual provision that's being prohibited is the transfer of liability for negligence. And then the other amendment is pretty obvious, that in Section 2 of the bill, it talks about the bill applying to contracts entered into or renewed on or after January 1st, 2026. That date is obviously already passed. So I'll rely on your diligence to read the rest of my submitted testimony. And I also recognize that this is an attempt to overly simplify a very complicated issue that has many tentacles once you get different industries and different applications. Completely understood. So ask for your support for LD 1761. I'm happy to answer any questions.
Thank you for your testimony. Committee members, are there questions? Yes, Representative Sinclair.
Thank you, Madam Chair. Sir, do you have any interest in taking a swing at Representative Lee's earlier question about exception C and whether that has a tendency to swallow the general rule that's being sought in the legislation?
I'm going to refer to my testimony by saying I'm not a lawyer, and I won't practice here on the stand. I will tell you though that section in the amendment was a product of HCIFS wanting to make a simplified bill even simpler, and there was a particular constituency that was looking for that section. So all of that is to say, it wasn't necessarily the proponents, it wasn't part of the proponent's objective. And I know that was the chicken way to answer your question.
Thank you nonetheless. Are there any other questions, Representative Caruso?
Thank you, Madam Chair. Thank you for your simple testimony. So I haven't had a chance to look at an example. But regarding transportation, I mean, we just heard an example about a logging truck going over a bridge from a landowner. And I heard that we've heard it a number of times that there is a provision in the transportation industry to protect. Can you speak to that at all?
Yes, so it's, and in my testimony, it's in Title 10, subsection 1459, where indemnity agreements and motor carrier transportation contracts are void and unenforceable. So we identified back in 2011, and you'll see the example in a nutshell. One of MMTA's members was hired by a big retailer to haul a load. Driver goes to pick up the load. It was a sealed load, so they had no ability to open it up to see anything inside. They took it from the distribution center to the store that it was going to. But in order to tractor trailers, when you back up to a dock, you have to open the doors before you can back into the dock. Otherwise, you can't open the doors. And when the individual did that, the load came down on them, injuring them significantly. And come to find out, our member didn't know that there was an indemnification provision in their contract with this large retailer. And they, as their self-insured workers' comp provider, we are obligated to subrogate against the negligent party. It was obvious there were no skid mats, there were no load bars, there weren't the things that typically you would do to protect those that are taking the freight off. But unfortunately for our member, they were the ones that were going to be responsible for that. Thankfully, they had a contract, an insurance contract, that paid the $700,000 that would have put the company out of business. So that's the real world example. And I think that in non-transportation contracts, a good example would be that, you know, if a big box store hires Bryant Park cleaning service, and you know, one of the big box store's employees runs over one of my employees while they're cleaning the store, and come to find out the big box store didn't provide any training. Well, that's negligent on the part of the big box store. Right now, there's a very high likelihood that that big box store, in their contract with Bryant Park Cleaning, has an indemnification provision, and Bryant Park Cleaning is going to be responsible for the injury caused to my employee at no fault of my own.
Okay, thank you.
Additional questions, committee? Seeing none, thank you.
Okay,
The
thank you.
next person who wishes to speak in support, please step forward. Is there anyone in the committee room who wishes to speak in support of this legislation? Seeing none, I would just check to see. I don't think we have anybody online. And we do not. So if anybody is in the committee room who wishes to speak in opposition to this legislation, please step forward. Welcome.
Thank you. Good afternoon, or almost evening, I guess, but Senator Carney, Representative Coombe, and esteemed members of the Joint Standing Committee on the Judiciary. My name is Anthony Hauer, and I'm here representing Irving Woodlands and NBM Railways. I'm here testifying in opposition to LD 1761. Our companies own and manage approximately 1.3 million acres of timberland in Aroostook County, and we operate more than 350 miles of railway here in the state. All our lands at our choice are open to the public to access hundreds of miles of roads, ATV trails, snowmobile trails, and I might add the best hunting and fishing properties in the Northeast. We have hundreds of agreements in place that support local use as well as Maine's tourism and logging economy, all of which have indemnity provisions of differing sorts. This bill, as currently written, is sweeping ban on indemnification agreements, even when both parties willingly agree to undertake this in private contracts and agreements. The term unintentional negligence is used in this bill is not defined in Maine statute or case law. It is unclear if the drafters of this bill want the term unintentional negligence to refer to negligence as defined in statute, or are looking to redefine the term. Is the intent to redefine the term and forego hundreds of years of case law that exist in the state? That's open for discussion. Currently, landowners in Maine have some protection from liability from 14 MRS 159 for outdoor recreation. Very successful statute. This draft bill does not explicitly state that it does not impact that law. It is a potential conflict. If this bill moves forward, we encourage the legislature to clearly indicate that there be no impact on this existing statute that allows landowners to have the public recreate upon their lands. Is it the intent to eliminate the right to have both parties agree to indemnification and contracts and have landowners increase the amount of liability insurance required for those contractors to carry before entering on private lands to undertake work? Are leaseholders and guides with bear baits agreements able to incur increased liability insurance coverage to fix a problem that has not been identified in our knowledge? These folks are not covered under the recreational statute in Maine because they pay a fee for the right to use the land from the landowner. This bill would make many landowners question the future viability of the North Maine Woods, an organization that's been in place for over 50 years. And about 100,000 visitors a year go through the gates to access the 3.5 million acres of private lands, but they all agreed to indemnify the organization and the landowners, which would not be allowed under 1761, as I understand it. Commercial logging and farming operations are not covered under the current recreational statute in Maine. Today, these parties enter private agreements to indemnify the railroad owners to cross tracks, to access lands and fields and other aspects of their farms. Are these gone under 1761? Can't imagine any case where we'd want someone putting a new crossing on a railway, regardless of the negligence issue, if there was no coverage or there was no ability to indemnify the railway owner. So I have not heard any examples of what this bill is trying to fix, other than changing the historic contracts and agreements that these parties enter under private negotiations. And do we really need the legislature to upset this tradition of private agreements because some insurance trusts would like it and probably profiting from it in the end? Again, if there are specific issues that need addressed, let's have that discussion and address these specifically. Sorry, not an overly vague, broad brush piece of legislation, once again, changing the rules for landowners, private landowners in the state of Maine.
Thank you for your
Thank you
testimony.
for your time, and I urge you to vote ought not to pass as is. Thank you.
Thank you. Committee members, are there any questions? I have a very basic question for you. I know you referred to the phrase unintentional negligence. Is that a phrase that was used in the original bill or in the amendment that the HCIFS committee passed?
I believe it's in the amendment. I don't have it with me.
Okay, we'll look for it. Thank you. Any other questions, committee members? Seeing none, thank you.
Thank you.
Would the next person who wishes to speak in opposition, please step forward? Welcome.
Ready?
Yes, please begin when you're ready.
Yeah, thank you. Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Dirk Gowans, and I am the Executive Director of the Ski Maine Association. We represent the interests of the ski industry in Maine, and I live in New Portland, and I'm here to testify in opposition to LD 1761 and Act to Prohibit Indemnification Agreements. While this proposed law appears to have support from several different construction-leaning organizations and associations, the broad language is what has us concerned and will have unintended consequences to businesses that rely on these types of indemnification agreements to operate. The ski industry is one of the businesses that will be adversely affected by this law should it be allowed to proceed in its current form. As a brief history, in the 1970s, a series of court cases related to ski accidents ran through the courts in various jurisdictions around the country. Some of these resulted in large verdicts against ski area operators. As a result, nearly all insurance companies pulled out of the ski industry, resulting in a loss of skiing facilities nationwide because their insurance was either not available or the cost was just completely unaffordable. In the early 1970s, Maine had as many as 70 operating ski areas. Today, we have 18. The Maine legislature, along with legislators across the country and nearly all the states with ski areas, stepped in and created common sense legislation that requires all skiers and snowboarders to accept the inherent risks of the sport. In Maine, it's MRS Title 32, subsection 15-217, skiers and tramway passengers' responsibilities. And just real quickly, acceptance of inherent risks. Because skiing as a recreational sport and the use of passenger tramways associated with skiing may be hazardous to skiers and passengers, regardless of all feasible safety measures that may be taken, each person who participates in the sport of skiing accepts as a matter of law the risks inherent to the sport, and to that end may not maintain an action against or recover from the ski area operator or its agents or representatives or employees for any losses, injuries, damages, or death that may result from inherent risks of skiing. On a more recent note, in 2010, the Oregon legislature struck down its skier statute and replaced it with a much less stringent version. The result has been a series of large verdicts against ski area operators extending even down to mountain biking in the summer. This prompted every insurer to leave the Oregon market except for one, resulting in extreme increases in premiums and the closure of several ski areas and nearly all mountain biking facilities in the state. Here in Maine, the ski industry employs over 5,000 people at its peak season each year. In rural Maine, where all our ski areas are located and where jobs are desperately needed. We urge you to vote not to pass on LD 1761. And just real briefly on the Oregon part of it, because the insurance prices went up so much in the past few years, just to give you an idea, the lift ticket price in Oregon this year surpassed $225 a day. Okay, $225 a day for one lift ticket. Okay, in Oregon, based on the fact that insurance premiums have increased so much. We don't want that to happen here. I'm happy to answer any questions. I know my time has run out. The amendments that were in there were partly because of our efforts last year and addressed some of our concerns, but not all of them, because we do have some legislation here that protects the ski area operator for skiing accidents, but ski areas can no longer operate just as ski areas. They do things like mountain biking. They do all kinds of different events.
Thank you for your
and so on.
testimony.
So thank you very much.
Let's see if there are any
Appreciate it.
committee questions for
Sure.
you. If you can just wait a moment. Committee members, are there any questions? Yes, go ahead.
Thank you, Madam Chair. Thank you for being here and for this information.
Sure.
So you had referred to some sort of amendment or, something that you would be more amenable to. What would that be?
Well, if there was an exception for recreational activities in the state in general, that would be more exempt. So the amendment that was made just deals with individual liability or individual liability agreements. But if it was more specific to the recreation industry, that would be something that would be more acceptable. Or if the entire bill was just relabeled and redone, as Representative Henderson mentioned about dealing with strictly the construction industry or some other industries that are mostly affected by this, and narrowed it down like many other states have done, where they've gone specific to where it's really means the most. And that is, I believe, the construction industry is where it's applied the most.
Thank you.
You're welcome.
Thank you. Any other questions, committee members? Seeing none, thank you.
Thank you.
Next person who wishes to speak in opposition, please step forward.
Good afternoon.
Welcome.
Senator Carney, Representative Kuhn, distinguished members of the Joint Standing Committee on the Judiciary. My name is Nate Moulton. I'm the Director of the Office of Freight and Business Logistics at the Maine DOT. Maine DOT is opposed to the amendment of LD 1761. As written, the amendment could negatively affect private landowner agreements related to third-party access. By eliminating blanket indemnification language and liability transfer provisions, property owners may be less willing to enter into these agreements or may choose to not renew existing agreements to allow access or crossings on their property. If landowners do proceed with these agreements, it's very likely there will be an increase in associated fees or an imposition of higher insurance requirements on the party that is going to use their property. This will be because of the increased liability and insurance exposure. One example are private rail crossings and utility agreements in rail corridors. While some private crossings are established through easements, many of these are through agreements going back in many years with prior railroads and even with current railroad owners. Private railroad crossings, leases, and utility crossing agreements typically include blanket indemnification provisions to protect the railroad and or the rail property owner. If these provisions are weakened or voided by law as proposed, rail corridor owners may be less inclined to enter into or renew private and temporary crossing agreements for camp roads, farmers, wood harvesting, and similar users. In addition, annual fees and insurance requirements are sure to increase. This is a concern specifically to Maine DOT, along with other large landowners or corridor owners. We own 600 miles of rail lines in the state of Maine. Some of them are leased to private operators. Some of them are not in operation, but still are maintained for potential future rail use or for trails. Even in current conditions, we do require blanket indemnity for us and our operator if we have a rail operator. Even under current conditions, it can be difficult for individuals or groups to obtain the affordable insurance for these private crossings. This will only get worse if LD 1761 were to pass. The proposed amendment will likely make insurance even more difficult and costly to acquire. Again, in most of these cases, people are coming to us to try to cross our property. We're not soliciting them to do work for us. That is something separate from us. So another concern related to the potential passage of LD 1761 involves the state-sponsored Downeaster passenger rail service. There are blanket indemnities from the Northern New England Passenger Rail Authority, Amtrak, and station communities to the track owner, CSX. If this language were to change, those would have to be renegotiated again, likely add cost, increase insurance, those types of things. And that is a state-sponsored service. All this shortfall in that service is paid by the state of Maine through the Department of Transportation. And I'll end there because I'm out of time.
Great. Thank you very much for your testimony. Committee members, are there questions? Seeing none, thank you. The next person who wishes to speak in opposition, please step forward. Welcome.
Thank you. Good evening, Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Maureen Terry, and I'm the Legislative Liaison for the Department of Economic and Community Development. Thank you for the opportunity to provide testimony for this bill proposal for the amendment. I'm here today to testify in opposition of an act to prohibit the transfer of liability relating to a party's own negligence or liability in contracts. While the committee amendment narrows and clarifies the original bill language, it does not resolve the fundamental concern. This proposal inserts the legislature into an area of law that's already well developed, highly fact-specific, and best handled by the courts. Contractual allocation of liability has long been governed by common law principles, judicial interpretation, and a case-by-case analysis. Replacing that framework with a blanket statutory prohibition risk creating more uncertainty, not less. Maine courts already possess robust authority to invalidate contractual provisions that are unconscionable, ambiguous, contrary to public policy, or that improperly attempt to shield a party from responsibility for intentional wrongdoing. Judges routinely evaluate indemnification and liability transfer provisions, considering the party's relative bargaining power, the clarity of the language, and the specific facts at issue. This judicial discretion allows for the law to evolve responsibly and avoids unintended consequences that arise from a one-size-fits-all statutory rule. By declaring entire categories of transfer of liability provisions void and unenforceable, the amended bill risks disrupting well-established commercial practices that Maine businesses, municipalities, nonprofits, and contractors rely upon every day. Construction contracts, public works projects, professional services agreements, equipment leases, and private-public partnerships frequently include negotiated risk allocation provisions that reflect insurance availability, pricing, and the realities of the work being performed. Prohibiting these provisions outright may lead to higher costs, reduced competition, and fewer willing contractors, particularly for complex, high-risk projects. Experience in other states illustrates these risks. States that have adopted broad anti-indemnification or liability transfer statutes have faced years of litigation to determine that contract language is still permissible, how insurance provisions interact with statutory prohibitions, and whether parties can achieve similar outcomes through alternative mechanisms. Rather than eliminate disputes, these statutes have often shifted them from contract negotiation to the courtroom, driving up legal costs and delayed projects. In some cases, insurers have responded by tightening coverage terms, as you've heard. I'll skip the rest of this and just say, in short, the amended bill still attempts to solve problems that Maine law is already equipped to address. It substitutes rigid statutory rules for judicial judgment, undermines freedom of contract, and risks destabilizing established risk management practices across multiple sectors of the economy.
Thank you for your
Thank you for listening.
testimony.
Yeah, sorry it was a little long. It's been a minute.
Committee members, are there any questions? Yes, Representative Lee.
Hello.
Hello.
You mentioned that there are other states that have what you call broad anti-indemnification provisions. Do you have some states in mind, or that might be a work session question?
That might be a work session question. I do know about the Oregon work that the representative from the ski industry mentioned. I've had a couple of conversations with the AG's office. that's not coming to mind, but I'll bring you some of that for
Thank
the
you.
work
Appreciate
session.
it.
Yeah, absolutely.
Yes, thank you very much. Other questions, Representative Henderson?
Thank you, Madam Chair. I'm just curious if you ever served on judiciary.
No, I have
Thought I could get some tribute out of the shadow.
Also, I'm not a lawyer. No tribute for you guys.
Anything else, committee members? Seeing none, thank you for your testimony.
I have
Yes,
one
Representative
question.
Caruso.
Thank you. And thank you. This is very helpful. I just had just a quick question. You referred a couple of times in your testimony to using the judicial process to work through agreements. That would, what you're saying is in this case, the way it's been proposed, the David
Yes.
would have to take Goliath to court.
Correct.
And that is what you're implying.
Yes, and more to the point, the Attorney General's office. That's where my information comes from, having not served on judiciary nor being an attorney. My conversations with the Attorney General's office have said, I'll say this anecdotally too, because I didn't write that conversation down, but the courts have great flexibility in being able to solve these problems as it stands for the moment. I think maybe you're asking about what about beforehand? Why would we go there? Maybe I'm wrong. Maybe I'm overlooking it or overthinking.
It was and I could be totally misunderstanding your testimony. It seems that this is saying there's no need for this change of law because there's already a provision where the corporation or a company or person can bring this to the court system and have them go to bat for them, so to speak.
Correct.
But what I'm just clarifying is that would mean that the David would go, maybe it's not to the court directly, but petition the AG to, hey, this is happening. What do you think about this? And then, so that would be interesting to find out how often the AG's office is inclined to do that.
Yeah.
The process for that, I would imagine it wouldn't be quick. I don't know.
I can definitely ask about that. And I think you had asked about getting information from somebody else about getting kind of a numbers as to what that's going to look like. So, but if you need that from me, I will happily get that for you.
Sure, just to
Yep.
try to understand better.
Heard.
Thank you.
Yep.
Thank you very much. Representative Henderson?
Thank you, Madam Chair. So follow up on my previous question. I was just given intel that you were in leadership, so therefore you were a member of every committee. So something to keep in mind for the work session.
Noted. Thank you, Representative Henderson. I appreciate that.
Anything else, committee members? Thank you.
Thank you.
The next person who wishes to speak in opposition, please step forward.
Good evening, Senator Carney, Representative Kuhn, members of the committee. My name is Stacy Bergendahl. I'm the senior staff attorney for the Bureau of Insurance, and I'm here to speak in opposition to LD 1761. I'm not going to read my testimony verbatim. Y'all have already heard me talk about this subject quite a bit. I just wanted to address a couple of the points that have already been brought up and sort of reiterate our position on the bill. So we would agree with what the DECD just said about there already being a remedy in the courts. Traditionally, whether or not contract provisions are enforceable has been something for the courts to decide. So that is already a remedy that is available. And I'd also like to point out that if you have a complicated statute with lots of exceptions and carve-outs, and difficult terms to define or interpret, then it's not going to reduce the level of litigation, because then you're going to have to decide whether or not the particular contract division fits within the boundaries of the statute. So I'm not sure that that would accomplish the goal of reducing litigation in any way. I'd also point out that just in general, having a very complicated statute with a lot of carve-outs or exceptions is difficult for for people to handle and for people to know what the law actually means and what is protected and what isn't. Having said that, if the law moves forward, we're going to ask for some more exceptions. Mainly because, so we do have an exception in the amendment that deals with insurance policies, but there are certain insurance adjacent activities that aren't that aren't insurance policies and that aren't issued by insurance companies such as municipal risk pools and other institutions like that we think would need to be added. So we would want to cover anything that manages risk in that way. Additionally, we would also like to stress that we would be in favor of an approach that more closely mimics the approach taken by other states. And I have linked in one of the footnotes in my testimony a chart that shows, I think, all of the states that have adopted similar provisions and what industries they relate to. And they very closely mimic the examples we've heard tonight in terms of construction and snow removal. Logging is kind of particular to Maine, so I think that one doesn't come up that often, but that's a sort of a geographical limitation. But certainly construction, the design and build industries and snow removal are definitely areas where this has been covered in other states. And so we would encourage, if the bill goes forward, that it move forward in that direction. And we also have several drafting considerations that I list at the end of my testimony to talk about specific wording, namely the idea of naming a particular kind of insurance as an example and then saying all insurance. That's kind of confusing. And also when you have a provision that says that they have to add an additional insured, we'd like to point out that that can only be done by the insurance company and the insured and not via any other mechanism.
Thank you for your
Happy to answer any
testimony.
questions now or at the work session.
Are there any questions, committee members? Yes, Representative
I'm trying to deduce, and maybe you can help me in that. I'm trying to deduce why it is other states limit it to certain industries. Is there a legal reason for that? Perhaps like a contract clause?
Sure, they may have other contract provisions, or I think, in my opinion, it would be because they also quail at the thought of coming up with every possible unintended consequence and trying to account for that.
Additional questions, committee members? Seeing none, thank you. Would the next person who wishes to speak in opposition, please step forward. Welcome.
Thank you. Senator Carney, Representative Kuhn, honorable members of the committee, Jim Mitchell, here today on behalf of the Maine Mayors Coalition. It's an organization made up of the mayors from Auburn, Bangor, Biddeford, Lewiston, Portland, Rockland, Saco, Sanford, South Portland, Waterville, and Westbrook. And they advocate at the direction of the mayors. We're advocates for the citizens of those communities. I'd like to emphasize at the outset, Maine's municipalities, even its cities, are not Goliaths. But as Mayor Jeff Harmon of Auburn pointed out to me today on a phone call just a few hours ago, their interest in this bill lies in the fact that his city has literally hundreds of contracts with indemnity provisions protecting the taxpayers. This is a critical element of contract negotiation and agreement, is to ensure that if there are contractors who have low limits on their insurance, a litigant might then turn their decision-making towards the city to make whole if an injury were caused. Another example of this in municipal government is many municipalities in Maine have franchise agreements with cable companies, and they provide access to the public way to those companies to install their cable to deliver their service to households and businesses of that community. Those franchise agreements almost always have the cable company indemnify the city or the municipality in the event of an accident in the public right of way. There are a series of examples that go on to show that it's critically important that as you look at this legislation, that it not unintentionally undermine those contractual provisions in a manner that is detrimental to the residents and taxpayers of Maine's municipalities. With that, I'd be happy to take any questions.
Thank you for your testimony. Are there questions, committee members? Representative Lee and then Representative Henderson?
I just wanted to note how impressive it was that you, without reading something, listed all of the cities in alphabetical order.
I did have my card. I had a cheat. I was afraid the mayors might be listening, and if I forgot one, I'd be fired.
Now I'm complimenting your honesty and
And integrity, I'm sure.
Representative Henderson.
Thank you, Madam Chair. Representative Lee, I anticipate the same compliment my next time I do my introduction. Okay. Fair? Okay. So you asked us at the end of your testimony, and thank you for your testimony, by the way. You asked us to try to ensure that we craft this in a way that doesn't have unnecessary consequences on our municipalities. Do you have any suggestions or frameworks on how we should kind of direct those amendments in that conversation?
I think that's a fair question, Representative Henderson. The problem is I'm not prepared to talk about that here today because literally hours ago, the mayor's directed me to come testify against the legislation, but we'd be happy to convene the mayor's legal counsels and see if we come up with some solutions.
Will you be available for the work session?
Yes, I will.
Thank you.
Representative Kuhn.
Can I just ask that you upload testimony to the committee? You've just raised some different issues than we've thought about with other or heard about from other witnesses. So I'd like to think about it some more.
Yes, I'll do my best. We're preparing that now, and I expect to have it in the next 2 days, and we will then provide it to the committee.
Thank you very much. Anything else, committee members? Seeing none, thank you.
Thank you very much.
Would the next person who wishes to speak in opposition, please step forward. Welcome.
Thank you. Josh Stearman with the Maine Bankers Association. Senator Carney, Representative Kuhn, the committee, thank you for the opportunity to speak today. The Maine Bankers Association is a statewide trade group representing the banks across our state. These are 9,000 employees, the folks that help you get a loan for a mortgage or a small business or a safe place to put your deposits. The Maine Bankers Association is opposed to the bill. There's been many thoughtful points made already, so I'll keep my remarks brief. What's being proposed today is sweeping, broad, and would affect every business-to-business relationship across the state. That is a serious and frankly destabilizing impact of this bill. We heard from proponents, it's something that really hasn't been done in any other state. And in the one example we did hear, it was really problematic and disruptive. The laws we have today allows free contract and permissive in a way that businesses can enter into relationships with each other, and the contract means something. The writing means something. I think that is helpful for business climate. A bill such as this would be deeply destabilizing, and we've spoken in this committee and in others about the challenges of the business climate here in Maine, and frankly, I think this would make it more challenging. Specific to banking, one example is commercial loan documentation. This bill would cause effectively every commercial loan to be rewritten in the state. That would have a troubling impact on the availability of credit. So frankly, I urge you to proceed with caution. This would be a 180-degree change from the current law, and I think that's something that should be considered cautiously, perhaps in a study commission. And if you do wish to move forward, perhaps it could be directed at the industries where we've heard there are some concerns. That seems to be concentrated, particular industries, so I'd urge a targeted and more focused solution. I'll leave it at that, but thank you for your time. We urge you to oppose the bill.
Thank you for your testimony. Committee members, are there any questions?
Thank you.
Thank you. Would the next person who wishes to speak in opposition, please step forward. Welcome.
Good evening, Senator Carney, Representative Kuhn, and distinguished members of the committee. I'm Joshua Tardy, resident of Palmyra, Maine. I'm a lobbyist at Mitchell Tardy Jackson, and I'm here today standing in for Nate Cloutier on behalf of Hospitality Maine and the Maine Tourism Association in respectful opposition to LD 1761, an act to prohibit indemnification agreements. Nate's testimony is circulating. sort of the third and fourth and fifth verses are the same as the first. I'm not going to just repeat testimony and read it to you, but generally speaking, these two associations also opine that this legislation is overly broad, and it's really improperly inserting government into highly negotiated contractual negotiations between private, typically not Davids. And so this search and rescue for the Davids in the room, there are none here. Okay, and what is absent from the discussion is terms like subrogation and how the court through judicial doctrine will look at the enforceability of a particular indemnification clause on a case-by-case basis and recognizing that it's very fact-driven. But typically the process is a private citizen is injured and brings a tort claim on a premises liability type of theory. And good plaintiff's lawyer search for defendants. And it is within those pleadings in the insurance defenses and the policies that pay for those defenses where motions for summary judgment are pled and they are fact-driven, and the judges will determine whether in fact an indemnification clause offends notions of public policy or not. But the fact of the matter is these are highly and intensely negotiated provisions. In the hospitality industry, you can think about the consequences of who's at fault and how are these indemnification clauses going to impact room prices and access to hospitality accommodations. I'll certainly be here for the work session. I'm happy to answer any questions.
Thank you very much. Are there questions, committee members, at this time? Seeing none, thank you very much. The next person who wishes to speak in opposition, please step forward.
Senator Carney, Representative Kuhn, members of the
Welcome.
committee. Thank you. My name is Charlie Sultan. I'm here on behalf of the Maine Association of Insurance Companies. Generally of me too, but I'll just give you a few things. Insurance is there to help protect some financial security for contracting parties. That may and when we talk about contracting parties, we're not talking about just private parties, but the state and municipal and local governments as well. The state of Maine can be considered a Goliath for most of the parties that is contracting with, whether it's a snowplow operator, the operator of a computer system, any number of systems. You guys think of the wide variety of contracts that just the state enters. As Mr. Mitchell said, municipalities enters. I had the privilege for about a year and a half to sort of act as general counsel to a company that interacted with municipalities around the country before they were bought out. And then they got other counsel. But I literally negotiated dozens and dozens of contracts with large municipalities and resort towns and so on, dealing with specific issues that this client of mine was going to assume for them, collecting revenue, doing licenses, things like that. The first clause I went to was the indemnification clause to see how the town was trying to weigh those responsibilities and liabilities. And I negotiated every single one of those to try and make them as close to a mere indemnification clause as I could. But there were reasons why sometimes the municipality had to have a larger escape of liability to protect themselves and so on. So it really is fact specific, which is why most of us are opposed to this particular bill because it is so broad. And the circumstances of which private parties and governments with private parties and each other enter into contractual arrangements is so broad. So a sweeping one is really detrimental to the continued flow of commerce agreements between parties. I will say back in the 127th, there was a bill to try and deal with indemnity clauses in construction contracts. It was LD 587. I believe it died between the houses. But otherwise, the courts have been very good at making sure that such clauses are fair, not unbalanced, nor, against public policy. So there is a body of case law that does help define parties' roles and relationships, and it's worked. And I'll end there.
Thank you very much for your testimony. Are there questions, committee members?
Thank
Seeing
you.
none, thank you. The next person who wishes to speak in opposition, please step forward.
Good evening, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Robert Caverly. I'm the Senior Government Relations Consultant with Resolve Government Relations. And I'm here on behalf of CSX Transportation Railroads to respectfully oppose LD 1761, an act to prohibit indemnification agreements. Testimony is being passed out, and I don't need to repeat a lot that has been said already. We've had some railroad discussion already. I would share with the committee that CSX acquired Pan Am Railroads in 2022 and has significantly expanded its footprint in New England, and including much of the rail infrastructure in Maine. And a part of that includes, as mentioned earlier, the Downeaster line. CSX and Amtrak have several mutual indemnification provisions that allow that operation to be as successful as it is, and looking to improve upon it. Also, I would highlight for the group, we've heard about private crossings and what have you from previous testimony. I would draw the committee's attention that also sidetrack agreements that allow Maine businesses such as paper mills and other manufacturers to locate adjacent to the rail lines to ship goods efficiently. These agreements depend on indemnification provisions to manage risk. Limiting CSX's ability to rely on these provisions would undermine the private right to contract, complicate renewals, and discourage new business investment. For all these reasons and others that are in the testimony, we urge the committee to reject LD 1761. Thank you very much.
Thank you. Thank you for your testimony. Are there questions, committee members? I'm not seeing any. Thank you. The next person who wishes to speak in opposition, please step forward. Has everyone who wishes to speak in opposition been heard? It appears so. If you would like to speak neither for nor against, please step forward. Welcome.
Good evening. My name is Dan Burney and I represent the Maine Insurance Agents Association. We're testifying neither for nor this bill because it already, the last amendment we saw was exempting what's known as surety bonds. And I did want to explain the importance of that exception. Any project which receives federal money requires some things called a payment bond and a performance bond. And that's where, let's say the state hires a contractor to build a bridge. If they don't complete it, the payment and performance bond come in to pay to complete the bridge. But to get a payment and performance bond, the contractor has to sign an indemnification agreement where the insurance company can go after the contractor for what they pay to perform the bridge. I would point out surety bonds are probably the most complex insurance product there is out there. But if you like federal highway money, federal money for schools and things like that, you probably like surety bonds and don't want to interfere with our ability to sell that particular product. So I just want to emphasize that's a very important exception in this bill if you decide to proceed with it. From there, I will say when we were discussing this, my board had a lot of sympathy for small businesses being asked to sign very one-sided indemnification agreements. That being said, I think we kind of lean more in the camp, you probably need to take this one industry at a time. I would note, actually, landlord-tenant law already prohibits these kind of indemnification clauses in leases. And, as I was sitting here thinking about different situations, we talk about indemnification agreements. A trustee, typically the standard under trust law is good faith, not intentional or negligent. If a trustee acts in good faith, they're entitled to indemnification from the trust. Are we undoing that here inadvertently without thinking about it? There's also provision in the corporate law for directors of a corporation. If they're acting in good faith, is the standard for indemnification from the corporation. And I believe that's the same standard for personal representatives. Don't hold me. I'm off the top of my head. I could probably give you the statutes for the trustee and the corporation. So I just think the risks of a sweeping statute and unintended consequences are fairly large. But basically, there are some really one-sided indemnification clauses out there, but you probably have to take it one industry at a time. And I will leave with 1 minute left here. You've had a long enough day. Happy to take any questions.
Many thanks for your testimony. Are there questions, committee members? Yes, Representative Lee.
I had sort of skipped over the surety bond exception when I was reading this, and now I think I'm even more confused than I was originally as to what the general rule is, because I'm trying to figure out why you need the exception, because I'm not entirely sure how a surety bond fits into the general rule.
And it may not fit into the general rule. I think, you know, 'cause these are I haven't, to be honest, it's been about 10 years since I've had to read the indemnification agreement for a surety bond when it came up on another bill in insurance committee. These are very long indemnification agreements, but it's also not an industry you want to scare off from selling surety bonds, just because the consequences would be devastating. There's no federal highway money if they stop selling them here in Maine. It'd be devastating to a corporation like Chimbro too, although they could still do work out of state. Because I'm not sure, is there any provision in that long agreement that could be construed as indemnifying the insurance companies asking for indemnification for its own conduct? I'm not sure. So I think you're better off just leaving it alone. It's in there. And, you know, if you want, I could get a copy of one of the really long-winded and if you're having trouble sleeping at night, indemnification agreements they use, and we could kind of go through it and see if there's any part of it that triggers the general rule.
Thank you. Any other questions, committee members? Seeing none, thank you. Anyone else in the committee room who wishes to speak neither for nor against? Welcome.
Good evening, I guess, at this point, Senator Carney and Representative Kuhn. I'm Bill Ferdinand. I'm a lawyer from Brunswick. I'm here representing the Maine Forest Products Council. The reason we're speaking in this category is, as you heard today, that we have some members who are in favor of the bill and some members who are not. So what we wanted to provide you is some context and the considerations that we want you to think about as you look at this bill that we discussed, some of which you've touched on, but I just want to hit that. The first is that the current law, you should have you asked DECD, I think, to look at current law. The general rule right now is that the courts in public policy disfavor indemnification provisions that shift liability of someone's negligence to someone else. So the court will look at those provisions very carefully to figure out if the parties clearly and intentionally made that indemnification provision, okay? So they're going to look at the facts of the case and the situation and figure that out. So all the things that you've been thinking about are looked at, and having one law try to figure that all out at once is difficult, as you've heard. So I think make sure you understand the current law so that you know that if someone has one of these provisions, they can challenge them. It's not like they're rock solid, okay? The landowner liability defense law in Title 14, Section 159A has been brought up too. That protects landowners from recreational and harvesting activities, but it doesn't include exclusive uses or commercial uses and commercial timber harvesting in particular. So to deal with those things, we have contracts that try to address and assign liability between the parties to have the person that's either in control or benefiting from the use of the land be the party who assumes the risk. And those things are negotiated in different ways in different situations. And you're going to see examples of that in the written testimony that you get. There's a really wide range of situations, even within the forest products industry, that this applies to. It can apply to access to private lands for a variety of recreational uses, private crossing agreements for roads and trails and railroads, you've heard. Easements like conservation easements, especially through the Land for Maine's Future program, will have a specific provision that says that they have to allow public access. And with that, the easements will often say, well, you can have public access, but we're not going to be liable for the people who are on the property. And that shifts that back. And then harvesting services, that are not covered by the landowner liability law will have this indemnification provisions that you've heard about, because there are large areas of land where the harvesting occurs, and the landowner doesn't control the harvester a lot of times, where they go, when they operate, where they operate, all those things. So the harvester actually is in more control of the activities on the land for that contract, and they're in a position to control that risk, so they will shift that duty as well. So as you think about this,
Thank you. If you could wrap up in a sentence.
yeah, as you think about it, how will the landowners react? If this is changed, will it result in more controls, more costs for insurance, all the things you've heard about? How will this impact our state goals for conservation? We put more restrictions on contracts to mitigate risk? So all those things need to be.
Let's see if there are any
considered.
questions for
Yeah,
you.
yeah.
Committee members, are there any questions? Yes, go ahead.
Thank you, Madam Chair. Thank you. I was trying to scan through your different examples. I just, one thing that it hasn't come up and I haven't asked, but you do touch upon it, is, we have a lot of private land that our snowmobile and ATV trails are on.
Yeah.
And it's what a lot of my rural towns are need for their local economy.
Right.
And I was wondering how that would affect, if this were to go through with the large paper companies, like they used to be called paper companies, landowners.
How would they react?
Yeah.
Yeah, that's what they will react in different ways, but the reason they will have those things is because the trails for those uses are done at the, permission of the landowner. The landowner is not getting any benefit from that. There are many landowners who do not allow that. All of North Maine Woods does not allow ATVs. So it's not something, they're in the business of growing trees. Okay. And all the recreational uses that you talked about are extra things that other people benefit from by using the land. So the landowner will say, fine, you can do that on my own, but I'm not going to assume the risk of harm and injuries that for you being on my property. You have to do that. And it's the same with the ski industry. So.
Can I follow up?
You may.
One of the things that rafting companies have to do is we have all of our guests sign a waiver to the hydroelectric station that says if we stub our toe while we're there, we're not going to come after the hydroelectric station. Would this, in your opinion?
Very well, yeah, it very well could, because the hydroelectric station say, fine, you can put your rafts on the river, but don't sue us because something happened while you were on the river. I thought you were going to say that your customers were going to sign a waiver, against you.
Well, we have waivers back when I was a rafting company. So we have a waiver for our customers, but we can't even access the buses are carrying, thousands of guests to go down the river.
Right.
And before we can cross into the dam property and use the dam bathroom, we have to sign a waiver that says we're going to hold them harmless.
Yeah. And there are going to be lots of, and that's the basic point, is that there's so many things out there. And trying to have a law that addresses all those things is difficult. So, and I think you've heard that loud and clear.
Yeah, thank you for that real life example, Representative. Other questions, committee members? Seeing none, thank you. Is there anyone else in the committee room who wishes to speak neither for nor against? Welcome.
Thank you. Senator Carney, Representative Kuhn, and members of the Committee on Judiciary. My name is Amanda Egan, incoming Executive Director of Maine Woodland Owners, speaking today neither for nor against LD 1761. Maine Woodland Owners is a statewide nonprofit that advances stewardship of Maine's small woodland resources through the encouragement of good forest management, support for the state's 86,000 small private woodland owners, and a land trust that conserves working forests. While this bill aims to address power imbalances in contracts,
the broad and unclear language raises some questions for our organization. 1, how will this affect contracts and agreements that are mutually developed to benefit only one side? We just spoke about this a little bit. Private landowners frequently enter into contracts to allow public use of their land without any benefit to themselves. For example, 96% of Maine's snowmobile trail system relies on private landowner permission, which is granted through a variety of contracts, agreements, and permits that often include indemnification clauses. While the landowner liability law provides limited liability for recreational and harvesting activities, indemnification clauses bolster it. Small landowners are looking for full assurance that they are not increasing their liability by allowing the public to use their land, particularly when they gain nothing by doing so. Removing indemnification provisions could disincentivize landowners from opening their land to the public. 2, how will this affect conservation easements and other contractual agreements that preserve natural, scenic, and historic values? Land trusts like us throughout the state hold a vast number of conservation easements with private landowners that create permanent land use restrictions to benefit the environment and public. Conservation easements typically include indemnification clauses that protect both parties, the grantor, the landowner, and the holder, for example, the land trust, by defining and assigning risk. This is critical to ensure long-term viability of the easement. I'm not sure how many organizations would be willing to hold a conservation easement without indemnification. Additionally, indemnification is a common provision in federally funded conservation easements. 3, what about cases of joint negligence? We have indemnification provisions in some of our contractual agreements, including with the state, that extend to the joint negligence of the parties, but do not extend to losses caused by the indemnified party's sole negligence or willful misconduct. Are these provisions void and unenforceable? And 4, would directors and officers insurance be considered an exception in this bill? As a nonprofit organization, we rely on this insurance to carry out our mission without worrying about our financial resources being drained by the high cost of a legal defense in lawsuits and wrongful allegations. Thank you for this opportunity to bring these questions to the committee.
Thank you for your testimony. Committee members, are there questions? I'm not seeing any. Thank you.
Thank you.
Is there anyone else present in the committee room who wishes to speak neither for nor against? I don't think we have anyone online. That is still true. Okay. So is there anyone in the committee room who wishes to be heard in any respect on LD 1761? Seeing none, we will close the public hearing on LD 1761. Thank you, everyone. And committee members, I think our work for the day is done. Would anybody wish to make a motion to adjourn? And is there a second? All those in favor? We are adjourned. Thank you.